Hello, everybody, and welcome back to SLRP Court Night. I'm gonna have to rename this to Court Night, I think. All right. I mean, that's what's up. We're here in court. What's going on, Mr. Stewart?
The case that we have for the Charles Nilsson, he's fighting the trespass order. Just want to make sure that you did receive a copy from my assistant from the medical board over at the hospital stating the medical issue that he does have.
Yes, I did receive that. Of course, as it stands, though, you know that company has the right to trespass as they see fit. I haven't heard from them. I'll reach out to my assistant and see if they'll get in contact with the business owner, see if they want to rescind the trespass on him as well.
Yeah, I mean, we're still going to go forward, of course, with finding it. Just wanted to make sure we had a server outage. Just didn't know if that was one of the emails that didn't get sent through. Just want to make sure that you received a courteous copy.
Yeah, and is it Burger Shot, right?
Yes, yeah. I believe his friend was in court, our previous docket, over the same matter. They were there together.
Okay. Yeah, let me stand awkwardly in this position and ask my assistant.
Looks perfect.
Hey, will you reach out to Burger Shot and ask them if they want to rescind the trespass case 0044? Period. Thank you. Period. Okay. All right. We'll see what happens. And if they rescinded it for the last guy, I can't see why they wouldn't want to do it for him. But we'll see.
It's completely up to them. Just want to make sure you had a courteous copy of that.
Alrighty, everybody. So we're gonna get started with more actual court stuff here shortly. Of course, if this is your first time here ever, I am the district attorney for the county of Los Santos here in Silver Lining Roleplay. So I kind of oversee all prosecution of all cases. It's a really cool role that I really enjoy having. It's really a privilege and an honor. So I'm looking forward to continuing with the role. And for court tonight, we are doing court about once a month these days. So we have another one coming up December the 8th, I believe. We have a handful of cases on the docket tonight. We'll get through some traffic cases, etc. And hello to Phoenix and Zen, birthday Q Dog as well. I think I've streamed SLRP Court a couple of times in the past few months, so make sure to check out my past live streams for it. But you're here tonight. It's gonna be freaking awesome. Like I said, we've only got a handful of cases on tonight. Not a whole bunch, but enough. It'll probably be about an hour to 2 hours worth of content here.
Obviously.
Are you in a suit? Pardon? Are you a lawyer?
No, sir.
Are you someone important?
Not really.
You look like a man with a suit. You look important.
The district attorney himself right here, Mr. Pearson.
I got my suit from the Goodwill.
Someone talking to you. You want to be my attorney? Wow.
Hello, Mr. DA, are you alive?
Okay.
I'm not.
I certainly am. Gentlemen, sorry about that. What can I do for you?
I'll introduce you to one of my deputies here.
Let me come down and around. Be polite about it.
Get the fuck up.
How we
Deputy,
doing,
how are
sir?
you?
I'm taking
Doing well, sir. How are you?
Doing fantastic.
This is the guy who makes sure that those tickets we write get prosecuted. Well, not the tickets, but the bigger cases.
Sure.
Like I do.
Okay.
All
Well,
right.
let's try that again.
There we go.
That was
Good to meet
interesting.
you.
All right.
There was a
Good.
fly.
you
I just
go.
swat out of the air.
I gotcha.
I overlooked the tickets too, just not very
I don't
closely
know.
at all.
Chunky.
You know, if you ever end up having to defend a ticket, you have to do it yourself. But he does give good pointers. So,
Okay. Good to know. Good to know.
You got any snacks?
all right. I'm gonna show him around the rest of the place here. It's his first time working at the court, so
Okay, awesome. Well, I'll
You look like
keep an
you
eye in here, and if I need you guys, I'll give you a holler.
cool.
Sounds good. Good to meet you, sir.
He should be wearing should be wearing a radio and a body camera though, right?
So when I look through the uniform thing, there was nothing on there for it.
Hey,
So I'll just need to go to the
you.
closet, grab one.
Yeah, we should have
You
some
got
extra
any
ones laying
snacks?
around here somewhere.
Okay.
I just wanted to make sure, just God forbid, because sometimes people do have to go into custody for contempt or
$1.
something of that nature. I'd hate for there to be a use of force without a
No.
body camera, because then my job becomes really hard.
Oh yeah, we don't want that.
So you
All right, we can go.
you're
we can
gonna
go
want
change real
Yeah.
quick.
change and at the go look for the locker body armor number 6.
Okay.
Hey, you got $1?
And him back to shoulder.
I only got
Okay.
$10.
I think I saw one back here, right?
You got? Is any ones?
No, it's
Oh,
just
thanks.
a 10.
See,
Oh,
she had $1 for me. Broke bitch. Mm. Uh-oh. I got shit again.
Is that Mr. Zimmerman over here?
I believe Mr. Zimmerman's in his head.
Ah,
Sorry, what?
I was just making sure this is Mr. Zimmerman.
Yes.
How you doing, man?
Good, you?
Doing good, doing good. Have we had a chance to meet yet in court here?
Yeah, we met when I was doing with Marcos.
That's right. Sorry, a lot of faces, they blend together. What
Yeah,
do you
no
what do you
worries.
have on today?
Nothing right now. I'm just sitting here for
Okay.
in case there is a case that the judge needs a lawyer for.
Okay, cool, perfect.
I know Steve said he might be running late, so he asked me if he was running late to represent him, but for his failure to appear for his traffic when he was out of town.
Oh, gotcha. Alrighty.
But he said he's running late, so he should be here. But if he's not, then I'll hopefully try to talk to the judge.
Fair enough. Alrighty. Sounds good. I think the judge is running just a few minutes behind schedule, but we should be getting started here shortly.
Yeah, no worries.
I get paid by the hour.
Yeah, I don't, unfortunately.
What?
Hey, ugly bitch. Hey, you got another $1?
No, I gave you my $10.
Oh, you gave me $1.
Well, then who took my $9?
You're a drug dealer? I don't know.
I don't have a. Who? How do you know? Are you a cop? I think
Oh,
you're
I cop to you.
You might be an undercover cop. You smell like a pig.
Hey, you got drugs?
No, they searched me before I came in here.
Did they check your prison pocket?
I am putting shit up there. Excuse me.
I do.
Call me names. No, you could ask instead of just repeating it.
I mean, I'm sitting this time. I can smell snakes.
That was breakfast. Don't bring food to the courthouse. It's out in the car.
These benches hurt my butt. What? The benches hurt my rear.
Shut up.
It's horn in my poop. Turn your hearing aid.
Stop.
You wanna close your mouth?
God damn, that was convincing.
You want some sand sanitizer?
Well, that's
You got
fucking
some-
disgusting.
You got some of that?
Yeah, here.
Give it a little squirt, squirt.
There you go.
Thank you.
Mm-hmm.
Yep.
Okay.
It contains alcohol.
It looks like he just consumed hand sanitizer as well. So that was cool.
Hey, psst. My name's Jeremy. What's yours?
I'm Lori.
Lori?
Mm-hmm.
Are you on the streets? You smell like it.
Yeah.
Where do you stay?
Sometimes by the Vanilla Unicorn, and then
Oh, that's a good spot.
I can't say that thing. I'm trespassed. Yeah, I'm not supposed to go. But then I'm also over by the the bridge for Olympic Freeway by the gas station, and then under.
Oh, you ever tried Big J's Rat Barbecue over there? He cooks
No,
them
I
in the
haven't.
barrel. Well, you should try it.
Oh.
Sit down. You know. Yes.
Interesting.
Sorry, guys. Court seems a little delayed tonight. We're going to get started here as soon as we can.
Score after this.
I'm on probation.
And
I'm on probation. I'm not supposed to do that no more.
go ask them if they have any pills.
Oh, okay. Yeah, you do.
Oh, trust me, Zen. I work in a courthouse. I know.
Psst.
Yes.
You take medication?
Just Cialis.
Oh, never mind. Fucking old people.
You don't want one?
Shut the fuck up, stupid. Hey, psst. Psst. Hey, do you have court
District Attorney?
today?
Yes, sir.
I
give me
don't
more time,
know.
or
They
you
said
ready
I
to
had to
start?
come
Ready to rock and roll?
one of these days, so
Example?
I came to the court, and You know, anytime they're open, it's better than being outside. It's been a little
That's
cold
what
out.
I was just gonna say.
You're
We're
right.
here
You
'cause
know
it's
what?
warm.
Yeah.
And they
Also,
let me in.
yeah, they can't deny you access. You know, so like, yeah. But the only downside is they search you, so you can't bring in the goods.
What's his name? Hey, psst. John Suit. Psst. Who is that? When's the action happening?
It's like listening to stories, you know, when they do this stuff.
I want to be entertained.
Court will begin momentarily.
Thanks.
That guy smells good. He searched me on the way in here, and he gave me the hand sanitizer.
I think I made him gag.
Okay, here we go. You just left out of here, right?
Where do you think you're going?
All right, you all good. Courtroom will be right during your day. You as well.
All stand. All stand.
It's all rise.
All rise. Oh yees, oh yees, oh yees. This honorary court, being Superior Court of the State of San Andreas in the city of Los Santos, is now open and sitting for the dispatch of this business. God save the state and this honorary court. The honorary judge, Rehnquist proceeding.
Yeah, hello, hello.
You all may be seated.
Alrighty. Mr. Pearson, how are you, sir?
Doing well, Your Honor. How are you?
Good. Practicing my English. I'm trying to get my accent to completely go away. How am I doing?
You're doing fantastic, Your Honor. I can understand you perfectly.
Oh, thank you. All right, so what do you got for me?
Well, Your Honor, if we're on the record, I'll just state my appearance for all cases going forward on the docket this afternoon. Justin Pearson, bar number 239087. Probably
For the people, so noted.
Thank you, Your Honor. Probably the best case to call first is going to be the State versus De La Cruz, case 0124.
That's the probation?
Yes, Your Honor. It's going to be a full contested hearing.
All right. Mr. De La Cruz in custody, or is he still out on probation?
He's out of custody, Your Honor. I did see him. He is here present today.
All right. Mr. De La Cruz, step forward, sir. And welcome back.
Thank you.
All right, I want to remind you a couple things before we start the case swearing in, get all that going. You have the right to remain silent. You can speak to your lawyer at any time that you should so desire. Anything you say can and will be used against you in this court or in future courts. You understand?
Yeah.
All right. You may go have a seat with your attorney.
In Your Honor, it's going to be William Stewart for defense, bar number 241053.
Mr. Stewart, how are you?
I'm all right, Your Honor. How are you?
I'm doing good. I played 18 holes earlier. Got another 18 to do before the sun sets, so we'll see how she goes.
Well, there you go.
Yeah, good to see you again, then.
Well, you as well.
All right, you guys, what are we dealing with here? What are we talking about? What do you do?
So,
allegedly,
Your Honor, if I may, we are here on a amended second show cause for Mr. De La Cruz, and as I'm pulling it up here, I'll recite the order to show cause in and of itself. So, as Your Honor recalls, he was in front of the court not too long ago on a probation violation. He was continued on probation with no jail sanction. He was just given 8 hours of community service. That was due by December the 8th. To his credit, he has completed that community service, and he's gone even above. He went and did more than 8 hours. So, the state appreciates that. However, the order to show cause we are here on is that on October the 14th, he was contacted by Deputy Stolas of the Los Santos County Sheriff's Office outside of his probation, or pardon me, of his curfew hours. He was out off of Sonora Freeway a little after midnight, as I recall. And then additionally, so that's the first allegation. He was outside of his residence past curfew. The second allegation being that he had missed a court appearance and had a warrant for his arrest, which led to an arrest.
Mr. Dela Cruz, what are you doing, man?
I forgot to do the parking fines.
Did I not explain this to you last time? One of the very first conditions is not to commit more crimes. Getting a warrant sounds like you committed a crime to me. So we're going to continue here, but just know that I'm not thrilled with this already.
I will say, to his credit, it was not a criminal offense that led to the warrant. It is now criminal. It's a misdemeanor. It is a failure to appear for a written promise on a traffic infraction.
Oh, so he just doesn't respect our traffic colleagues enough to show up. Okay.
That is what the state is believing, Your Honor. So that's what we are here on, is that show cause alleging that he's out past curfew and had a misdemeanor warrant for his arrest, leading to an arrest on a misdemeanor crime, which, as I recall now, is going to be a conviction based on the time difference between the arrest and today. So it'll be a conviction for a new crime of failure to appear. So the state has a recommendation, Your Honor. What we're seeking today is revocation of probation and the imposition of a 6-month jail sentence. The defense and I have not come to an agreement. Sounds like they want to contest the allegations, so I am prepared to go forward today.
All right, so we'll treat this, Mr. Dela Cruz, just so you're aware, this is not a fact-finding in terms of guilt or innocence. We're just looking to figure out whether the allegations made here by the state are true or not true. Your lawyer should have explained this stuff to you already, but if you need a moment to speak with him, that's all right. I don't mind. I want to make sure we're respecting your rights fully here, but for now, what I'm going to do is I'm going to have Mr. Stewart give a bit of an opening statement, if you will.
Yes, Your Honor. My client has, as the DA has brought forward, has went above and beyond the mandatory hours, along with he has been on the straight and narrow ever since. The crime that is so-called probation violation for being out that day, all he was doing what every common day citizen would do that's in this court right now. He was calling in an illegal grow operation on the side of the interstate. He had a written note from his probation officer stating he was allowed to be out past his time. If it wasn't for him stopping to call in and stay to give law enforcement the information deemed necessary for them to...
Is that note on the record?
Yes, Your Honor, it is attached in the court case.
Yes, Your Honor.
Right, just briefly allow me a moment. I'm just going to take a look through there.
The state tends to have that.
Mr. Pearson, I do have a question for you, too.
Yes, Your Honor.
When I run that, so I'm connecting through your guys' database here, or I guess it's the sheriff's database, but it's given me a gang affiliation pop up when I'm looking at that record. Any idea as to why that might be happening?
It's actually something we need to address with you today as well, Your Honor. There is prior known gang affiliation. This was known to us well before the first probation violation. It stems from the original charge.
Okay.
Which my client has not had any contact with a gang organization since he was placed on probation.
I just wanted to make sure there wasn't something that I was missing new as far as that. Mr. Stewart, where on the record am I looking for the note from probation about being out after hours?
It should be in the evidence given over in the citation, I believe it is, from a Deputy Stolas.
If Your Honor would like, I can approach. I have a paper copy.
Yeah, please.
Sure thing. Let me grab that out of my briefcase here. Your Honor. This is a arrest report from Deputy Dennis Stolas. I believe it's on page 2. There's a photograph of the note that has been also presented to defense.
Okay, do we know, did he reach back out to his probation officer once he did return home? Or, no, he was arrested, so he couldn't have.
He was taken into custody.
All right. Okay, you may proceed.
Thank you, Your Honor. My client, along with completing more than the mandatory amount of community service, has went as far as to get employment, one being with a bail bonds company. He is filing paperwork through them. Along with that, he has received employment with the state, being that he collects garbage for the sanitation company.
That's good to hear.
Your Honor, my client, he has hiccups here and there, but he is doing everything he physically can in his being to make revocations upon his past mistakes. And it would be totally different, Your Honor, if my client was just out here doing everything on purpose or committing these violations with senselessness. But the probation violation that the state has brought up, it's what anybody in this court would have done. You're going to stop and call in the illegal grow operation. And because he decided to do the right thing on that day, we are saying that he deserves to go and spend the rest of his time behind bars. So should we have just left the illegal grow operation and my client be on his way?
So as to that, does the state have information that would with law enforcement at that time because he called that in?
Yes, Your Honor. I have all of that ready with my arguments.
Okay. All right. Mr. Dela Cruz, again, remember, you don't have to speak to me at all here, really. You can remain silent if you want to, but if you're willing, I'd like to ask you a couple questions.
Okay. Did you want me to stand up there?
Yep, come up to the podium, please. So, before we hear the whole story from the state, and remember, anything you say here could be used against you, what's going on? The last time we had this conversation, I told you, I mean, I was putting that GPS tracker on you. Why do you keep finding yourself in situations that are sort of hard to explain?
I'm not too bright.
Okay, but I mean, I don't think intelligence has anything to do with the fact that somebody with a history like yours keeps finding themselves into situations that are awfully close to trouble.
I'm doing my best to stay out of trouble.
So tell me in your own words then what I should do with you today. Because you heard what Mr. Pearson wants. He wants to throw you in jail.
You should let me keep picking up garbage.
Say it again?
You should let me keep picking up garbage. I'm really good at my job.
So hypothetically, if maybe I was to tell you that you can't leave your house except to go, do the essentials, buy groceries, go to work, instead of going to jail, would I ask you again in another month hearing that you decided to go out of your way to find something that you shouldn't have, and what's going to happen next time?
I mean, would I still be able like the movie theaters and stuff?
What do you mean the movie theaters? Like to work there? Like to pick up trash?
Like to go watch a movie?
I'm not restricting your internet access. There's nothing in this case that makes me think I might need to at this point, at least. I don't know why you can't watch movies at home.
But that's illegal.
You can buy them. There's like Flamazon and other services.
I mean, not the new one.
You can also use your local library. I believe they still rent out movies there.
But if I'm not allowed to leave home, then how am I supposed to go to the library?
Through their website.
I didn't know they had a website.
Yeah, they do. Not a lot of people know. I guess that's why they're struggling. But I just wanted to hear your perspective on if you could give me a really good reason why I should let you stay out there.
I'm good at my work. I haven't been bad.
Okay.
I stopped smoking weed, and I don't drink anymore. So.
Have we had him tested? Do we know?
I don't have any treatment provider reports on file, Your Honor. I believe you ordered last time that he would be subject to a drug and alcohol urinalysis upon return to court. Yeah, I have it here. This is based on his completion of community service, so it would have been the December 8th hearing. He would have also had a urinalysis done that day.
Okay. Let's see if we can't have the deputy there in the back of the courtroom take him upstairs, and they can take him to a private room, get a quick sample tested up there at the lab. Make sure he's in compliance with that once you're done with your statement here. All right, Mr. Dela Cruz, go ahead and, unless you have anything else you want to say to me right now, just go ahead and have a seat, and I'll have Mr. Pearson. No, or anything like that?
Sorry, Your Honor.
Okay.
Could you repeat that? I don't think we were able to hear you.
Can you, sorry about that, can you hear me now?
Yes, Your Honor, we can.
Okay. I didn't hear Mr. Dela Cruz say thank you, Your Honor, or anything. He just kind of left, so I was wondering about that.
Sorry.
Okay. All right, moving on. If the state wants to give me the summary of the allegations here, how we're going to proceed based on, it sounds like they're contesting both allegations at this point.
Yes, Your Honor. So, what I have here filed in discovery is an arrest report narrative from Deputy Dennis Stolas from the night of October 14th. Well, technically the morning of October the 15th. So, in summary, Deputy Stolas was responding to a call for service where Mr. De La Cruz had called in a potential illegal marijuana grow operation where he had located marijuana plants growing on the side of Sonora Freeway. Upon arrival, Deputy Stolas recognized Mr. De La Cruz as an individual on probation with a curfew. As Deputy Stolas pulled up on scene, he pulled his cell phone out to check the time. There was a time on the cell phone captured on body camera. And pardon me, this is the Monday morning, October the 14th. So in that report that I handed to you moments ago, page 3, that is a clip from his body camera that shows the time being 26 minutes past midnight. It is in the 24-hour time configuration, so it's 0:26 hours.
And that's the time that deputy arrived on scene?
That is correct. That is approximately 2
Do we know how
minutes.
much time elapsed after the call was sent out from dispatch?
I don't have that information handy, Your Honor. Based on my conversation with Deputy Stolas, that evening was not very populated with calls for service, so I believe that essentially
Relatively quickly.
Yes,
We could
Your
say
Honor.
a few minutes, more or less.
That is correct, Your Honor.
Would the defense stipulate to that it was approximately between when Mr. Dela Cruz called and when the deputy showed up?
I'm unable to speak on the exact time frame. I do know from conversations with my client, due to the conditions of the roadway on the date in question, he was heading towards Los Anos. The plants was observed being, I believe it's southbound back towards Toledo, so he had to drive down to turn around before being able to call it in.
His curfew note that I read said 2200 hours, so 10 p.m. That screen from the body camera footage there shows just about, what was it, 12:26? So that would have been almost 2.5 hours. I know the county does get busy sometimes, but is he alleging that he made that call before 2200 hours? Mr. Stewart?
Yeah, Sean, if you can give me 1 second, I'm going to have a conversation with my client real fast.
And Your Honor, the state has an opinion on that we intend to bring forward.
Sorry, say that again.
We have an opinion on their claim that we intend to bring forward during my statements here, Your Honor.
Okay, just give us a second to just confirm that.
Of course.
What you're wanting to claim is that it was a little bit after. Yes, Your Honor, that is what my client is wanting to claim.
Does he want to give us a time specifically that he called? Can he look on his phone maybe and see the history?
Yes, Your Honor, he's going to go through it right now.
And then, Mr. Pearson, do you have the communications department's reference ID for that call?
I do, Your Honor. Let me know when you're ready for that.
Go ahead.
It's 46421.
You called them at 23.
I'm not supposed to go through like the middle road, so I have to do like all the way down.
2230, correct?
I'll be just putting in an inquiry on the system there if you want to continue. Sorry, yes, Mr. Stewart.
After my client went back through, he made the call to the 911 services at 2330.
Okay, and we're still in agreement that that note said 2200 hours? So does he
Yes,
have
sir.
anything additional that he would like to add to explain the gap in time there?
We were trying to turn safely. my client, due to where it was located, in order to get back the right direction, he did have to go all the way down towards the Sandy exit, get off the exit there in order to turn back the other way on the interstate to head down.
And that took him, what, still, that's an hour and a half?
Roughly, Your Honor, yes.
All right. Mr. Pearson, go ahead.
Thank you, Your Honor. So, as I was previously stating, Deputy Stolas made contact with the individual known to be on probation, detained him under suspicion of a probation violation. Upon speaking with Mr. De La Cruz, he found out that Mr. De La Cruz had that pass from his probation officer to be out until 2200. Upon confirming the time, Deputy Stolas noted that it was 26 minutes past midnight upon initial contact. Further, as Deputy Stolas ran Mr. De La Cruz's information through the law enforcement database, he discovered that he had an arrest warrant. This arrest warrant, which is also in discovery, which I intend to enter into evidence, and that is warrant number 49680, issued by His Honor Thurgood Hansen. Actually issued the same day, 10/14.
Wait. The citation was issued the same day as the...
No, Your Honor, just the warrant.
Oh, okay.
Yeah, that warrant stems from a failure to appear on a different citation. If I take just a moment, I can find out the original court date for the citation. I believe there was a delay in the warrant actually being issued, as that court date would have been...
Oh, that's the senior judge there, so you had to wake him up from a nap or something to get him to sign that.
Pretty much. And I believe that court date was October the 13th that he had missed, so the warrant went out the next day. So once Deputy Stolas noted that there was an active warrant...
And the original offense was from what day?
Let me verify that, Your Honor, one moment.
Your Honor, I do believe this citation stemmed previously before the new court system had been introduced.
We'll have to double check that because it was supposed to be set up so that that wouldn't happen, but I will take a look.
Well, Your Honor, I will say, as I'm looking through here at information, I'm seeing that Mr. De La Cruz has actually picked up a handful of new traffic citations during his time on, in between the time I filed the show cause until now. That may lead to a different outcome here. I am still, because of the amount of traffic citations he's gotten, I am struggling to find the initial citation that caused the warrant. I believe that citation is citation number 49029, and unnecessary use of unnecessary use of horn, issued by the Assistant Sheriff Hayes. And that was issued on September 21st. And I see a copy of the citation here does have a court date of 10/13.
Okay. Huh.
So all that information in hand, Your Honor, Deputy Stolas contacted probation and parole, confirmed that Mr. De La Cruz was out past curfew, and placed him under arrest for the misdemeanor warrant along with a violation of probation. Your Honor, what I want to bring your attention to is this, though. As he's already admitted, he placed that call to emergency services an hour and a half past curfew. His claim is that late at night, pitch black, while driving southbound on Sonora Freeway, he was able to observe marijuana plants growing on the northbound side, so clear across 4 lanes of traffic and a center median.
Better nose than some of those sheriff's dogs.
Exactly, and better eyesight, Your Honor. Pitch blackout with only your headlights on. So he's claiming to this court, Your Honor, that he notices that. Proceeds up to the Sandy Shores exit, turns around, comes all the way back to place that call. I believe, Your Honor, that is a false statement. Even a sheriff's deputy, trained, driving that highway with their standard, even with high beams on, it's not going to illuminate that far across the highway to catch somebody's attention. Unless, of course, Mr. De La Cruz was actually driving northbound towards Paleto
Objection,
Bay.
Your Honor. This is purely speculation on the DA's part. He cannot speak on my client's ability to see based on the observation of what he has seen with other people or officers.
Yeah, I'll sustain it. If you want, we can go down a road of expert witnesses and try and prove that a different way. What we will do here is I will go ahead and say that I'm just going to consider it as suspicious for now. I personally don't think a person would be able to just come across such a discovery in the conditions that are being described. But if needed, we can have a further evidentiary hearing to determine whether or not that merits any sort of review. For now, the objection on that point is sustained.
So what we can stick to, though, Your Honor, the facts being that he also claims that it took him an hour and a half to make a U-turn from the location he discovered it under regular conditions. It's less
I mean,
than a
I
mile.
certainly have driven the roads that you guys are talking about here, and I mean, even on the bad traffic days, I don't get the fancy red and blue lights, but I mean, it doesn't take that long.
Exactly, and Your Honor, that's not speculation. I think I personally have driven it. You're saying you've driven that stretch of roadway as well. We know the roadway. That's knowledge we have. So, all that being said, Your Honor, don't overlook the part that we had the failure to appear, which is a misdemeanor. It's now a conviction. So he has the new crimes. If you wanted to even let him off the hook, Your Honor, which is your right for the curfew violation, so be it. We're still sitting here with a new misdemeanor conviction on failure to appear. So with all that being said, Your Honor, what I've placed in front of you, I'm asking for his probation to be revoked and him be sentenced to 6 months in custody. This is not his first. This is his second probation violation being alleged in front of you. I don't think he's a good candidate for probation because he continues to violate. Additionally, one thing I do want to bring forward is that he was contacted by a couple of sheriff's deputies about a week or two ago. Deputy Stolas was present again, and Deputy Stolas made a call to the probation and parole department while speaking with Mr. De La Cruz, as Deputy Stolas noted that Jose De La Cruz is always wearing light blue clothing. It was discovered that that same light blue clothing is the color of the gang that he was known to associate with. So it is the state's request that there be a condition imposed that he not wear any colors associated with any known gangs.
Your Honor, what grounds is just because my client wants to wear a specific color that's trying to speak towards him being involved in something that he hasn't been involved in a very long time, just because he wants to wear a color?
Your Honor, they're known gang colors. It's the same thing that we have for folks on probation that can't wear all red, all blue, etc.
So is every color of the rainbow, Your Honor. But just because of that, we're going to start mandating people to wear a certain color, even if he's not having contact with the gang.
So here's what I'll say. I'm a big fan of the First Amendment. However, he has been found guilty of a crime, and I'm not saying that he's not entitled to exercise his First Amendment rights, but he's already past the point of conviction. I'm not going to say that you can't wear blue, but what I might consider doing here is in a manner that would reasonably cause people to believe he's showing association with the alleged criminal street gang.
Thank you, Your Honor. The state rests.
All right. Mr. Stewart, closing statements, if you will, sir.
Your Honor, all the DA's brought forth at this point is the probability of pure speculation on behalf of my client's ability to see, we've already spoke on that. This does not take away from the work that my client has put forth under the grounds of the law that's mandated him to seek a monitoring device, which he has done, to stay in contact with his probation officer, which he has done, to communicate with his probation officer on days like the day that was mentioned where he went to a family gathering, he reached out to his probation officer, gave him the grounds to be out past the certain time, but on that date, unfortunately, my client did witness an illegal grow operation. Your Honor, the citation that's on record was posted prior to the new court system. Under the research that I have done, that's something that we can look at further if you wish to do so.
The state objects, Your Honor. The defense's statement that the citation was issued prior to the new court system being imposed cannot be accurate, considering if you review the citation, there is a court date on there. The new citations given to deputies with a court date option happened after the new court system was put into effect. Therefore, he could not have had the citation issued to him prior to the new court system if there's a court date on the citation.
I am going to have to sustain the state's objection there, just given that those forms are approved by the state courts before they're passed out to the sheriff's office. That was a valid warrant, and he was taken into custody legally for it. We're not going to go back and dispute that at this point. I guess my question, Mr. Dela Cruz, you don't have to answer me, but why didn't you just pay it?
I kind of forgot.
Kind of forgot. They send you like 2 letters in the mail.
I came to court that day and I forgot to talk about it.
Kind of thing you probably should bring up when you come see me.
I was kind of busy with the whole GPS and everything.
Has he been? We have any report that he has failed anything with the tracker, keeping it charged, all that stuff?
Your Honor, deputies during the incident that I previously mentioned where Deputy Stolas contacted him, apologies, I don't recall the date, possibly 1 to 2 weeks ago. The initial call for service is that his ankle monitor was reporting him being out past curfew and not going directly to his known work location.
So he's not listening to the conditions, but he is charging the ankle monitor.
That is correct, Your Honor. And I will say, to his credit, the story that he gave to Deputy Stolas and the other deputies on scene did not result in him being placed under arrest, and probation and parole didn't want him back. It sounds like he left for work too early. Rather than going home, he circled Legion Square. It's abnormal if you ask me, but they didn't see it as a violation.
And do we have a formal recommendation from anyone at probation about this, or is it just your recommendation here?
It's just my recommendation, Your Honor.
All right. Mr. Dela Cruz, answer me honestly. This is going to make a big difference. Do you use drugs? And I'm talking about marijuana too here.
No, sir.
No, never? No, not.
I stopped using those the first court time that I came.
Okay, so it's been, 30 days? That's about enough time for pretty much everything I can think of to get out of your system, if you really have been clean since then. So I'm going to have that deputy back there take you up to the private room. They got the expedited testing lab up there, and we will hold this in abeyance until we get a result back. I promise you, if it's hot, if you test positive, you're going to go to jail. So you better hope that you haven't been doing any partying. The alcohol, I still don't have a reason to impose any kind of testing on you for that, other than just to make sure that you're not physically drunk today. The way you're talking to me, I don't believe that you are, but I'm going to have them just test you for that too when you go upstairs, okay?
Okay.
All right.
And, Your Honor, of course, if it's not clear for the record, I'll make the statement. In the event that his urinalysis returns positive, the state will motion the court to amend the show cause a second time and add the.
No, I'm
use
just
of
going
controlled
to
substance.
revoke his probation completely if he's positive. We're not doing that.
Fair enough.
I told him very clearly that is not going to be tolerated, and if there's one thing that pisses me off, it's people lying to me. So you promised me you wouldn't do it. You better hope it doesn't come up positive upstairs. Deputy at the back, you can approach and grab Mr. Dela Cruz. Bring him up there, please. Mr. Stewart, you can have a seat over there with your colleagues if you want while we wait for this to be addressed. I don't know how long it's going to take. They're usually pretty quick up there, but...
Your Honor, if I may.
You may.
Believe we have a very quick matter we can get out of the way. I believe Mr. Stewart represents this individual as well. It's a trespassing case. Case number 0044 for Mr. Charles Nelson. I believe we could handle this matter before Mr. De La Cruz is done.
Sure, that's fine. You may approach, sir.
Oh, thank you, thank you.
Your Honor, the state's been in contact with the victim in this case, which is the Burger Shot Corporation. They have.
This is Mr. Morbello. Is that Mr. Morbello out there in the stands I see?
Hi, Your Honor.
Hello. This is his buddy?
That is the state's understanding, Your Honor. The state haven't been in contact with the victim in this case. The victim, Burger Shot Corporation.
He have a trespass order too?
Yes, Your Honor.
Yes.
But the victim is willing to rescind the trespass order as of today and permit him to return to the property.
And you verified that comes from somebody who actually works for Burger Shot?
Yes, Your Honor. My victim service advocate has been in contact with their legal staff.
Well, that seems like a bit of a no-brainer to me, then. Is that something you wish to say?
No, I apologize. I regret what I did.
All right. Show that trespass vacated. We'll get the paperwork entered. Enjoy your burgers, Mr. Nelson.
Oh, thank you, thank you.
That's case 0044. Mark that down for the record.
Thank you, sir.
Tom. Thank you, Your Honor.
Huh?
Sorry for anyone watching. I was reconnecting to a Discord channel. That's my entrance sound. It's the fat cat going, huh?
All right, the system's updated on that. Upstairs, as to the original traffic offenses, and it appears the numerous other ones he's racked up, do you have any kind of a request for that, or what do you want me to do with all that information?
Pardon me, Your Honor. I'm sorry. Was that question for me?
For Mr. Stewart.
I'm sorry, can you repeat that, Your Honor?
So I just took a look here on my trusty handy-dandy floating computer screen here. He has, so obviously the warrant that we were talking about, there's a traffic charge underlying that. And then it looks like on one day he even got stopped 3 times on the same day. What do you want me to do with that information?
Your Honor, I would ask that the court, instead of revoking his probation, put a tighter leash on my client, permitting him to only leave under necessary grounds. We've already spoke on behalf of the probation violation that occurred on the date
Well, but so no, but answer me this though, specifically about the driving. What am I supposed to do with him? He clearly just is not learning. Like he's been stopped so many times, it's kind of making my head spin up here.
Your Honor, as much as I would like to speak on behalf of my client on that, I would like to speak to him about it. But if it comes down to it, I would be okay with a suspension of my client's license for the period that he
Will
is
that
on
not
probation
disqualify him from his new job?
No, Your Honor. I believe he does not drive the garbage truck. He rides on the garbage truck to collect the garbage.
Okay. State have any opposition then if we were to suspend?
The state... No, Your Honor. In the event that you do not revoke Mr. De La Cruz's probation, as is my standing request, the state does not object to imposing a driver's license suspension during the remainder of probation.
And when is his probation currently set to timeout?
Let me reference my notes here. I believe it's in January sometime. The state would also not be opposed to extending probation if Your Honor sees fit.
Yeah, we might have to see about that. But we'll wait for the defendant to come back before we make any sort of statements on that.
I have an end date of January the 18th, 2025, Your Honor.
Okay.
Concur on that, Your Honor, from my notes.
All right. Mr. De La Cruz, step forward. And Deputy Walker, if you want to let the bailiff know.
All tests came back negative from the lab.
I'm sorry?
All tests came back negative from the lab.
Negative. Your Honor, the results came back negative.
Well, it's somebody's lucky day, I guess. So, Mr. De La Cruz, apparently you can listen to some things, you just choose not to. Negative on the drug test makes me happy. I'm glad you're listening there. I'm glad you're keeping the GPS thing charged. But your driving record is not inspiring confidence in me. The state thinks you should go to jail. What do you want me to do? What's going to convince me that you're not going to get in more trouble if I let you go home today?
I'm trying to do better.
You're trying to do better.
I got a job. People told me to get a job, so I got a job. And then the first job didn't work out.
So this current job is sanitation, or that was the first job?
No, the first job was at the golf course, picking up golf balls. But Sergeant, I think his name was Sergeant Gisman. He told me to quit, so I quit that one.
He told you to quit. Interesting. I'll make a note of that.
And then after that, I got a job at the bail bonds up in Polito, and then they fired me because they said they can't have somebody on with a record. So I got a job at sanitation with the guy that I was doing the community service with. He gave me a recommendation for that, and I've been doing that for a couple weeks now. I've been really good.
There's no denying you've done some bad stuff. There's no denying you've done some good things in trying to ameliorate that. What I'm going to do today, I'm going to ask you now formally as to allegation 1 of the probation violation alleged by the state. True or not true? What's your answer?
What is that? Is that one the me being late for my curfew?
Allegation 1 is that you violated your mandated curfew by being outside of your residence between the hours of 1800 and 0700 hours.
Yeah.
That you're saying that that's true.
Yeah.
Your Honor, I
Okay.
believe that my client may be confused. I'd like to be able to have a moment with my client to discuss this.
All right, we'll strike that from the record. Give him a minute.
Thank you, Your Honor.
Mr. Dela Cruz, what say you?
Not true.
Not true. Okay. And as to the second allegation, which is that you were arrested on an outstanding warrant related to a traffic infraction on the 14th of October, 2024. True or not true?
That's true.
All right. I accept your allegation number 2 as true. As to allegation 1, honestly, I think you're lucky the state isn't throwing more in here, because I did impose a condition of not committing any more crimes, and it sounds like you've just been doing that anyways. But allegation 1, I'm going to find it true, but I'm going to impose a modified sentence here. I'm not going to revoke your probation. Because you've been doing some good stuff, and I do want to genuinely give you that chance to get your life back on track, we're going to do a couple things. So I'm going to sentence you to 6 months in the county jail, but it's going to be a sentence, which means that if you stay out of trouble and you keep going with your probation and you comply with some new terms that we're going to add here, then this can, poof, adios. But you break another rule and you're going 6 months. And it's not fun, I don't think. So do you understand kind of what we're talking about here before we get to the conditions, the ended sentence alone? I could put you in jail right now for 6 months at least.
So no more breaking rules.
Should have been something you were thinking about before, but yes, no more breaking rules, please.
Okay.
If you ever have any questions about what those rules are, what they allow you to do, you can contact your probation officer like you've been doing. You've got Mr. Stewart there. So in addition, I'm going to impose a couple conditions here that we are on top of what we already had. So you are to maintain the previous conditions. Additionally, you are not to leave your home as it is currently listed with the state. If you need to move for some reason, you need to inform the sheriff's office before you do that. They need to approve that report to me. The exceptions will be for essentials. You can go get food, you can get medicine, and by food I mean you can go pick up food from a grocery store. I don't mean you can go out to dinner at a restaurant. Need to go to the doctor's office. Better have a note from the doctor explaining that you were there and that you went straight back home afterwards. Anything other than that, because I'm going to suspend your license here, do you have a way of getting to those essential needs?
I have a bite.
So you'd be willing to accept a suspended driver's license with no drive to work conditions? You don't need to drive for your job, right?
I do need to drive for my job. I drove the garbage truck.
Okay. Have you spoken with your supervisors over there at sanitation to see if they'll let you drive even if I suspend you but put a condition that says you could drive for work?
I haven't contacted them yet, but
I guess you're gonna have to find out one way or the other.
oh, okay.
Your Honor, the state just wants to clarify in regards to the suspension. Is he permitted to travel to and from home for work purposes and then drive for work, or is he going to be required to utilize alternate transportation, such as a goober or public transportation?
Well, Mr. De La Cruz, you said you had a buddy. How reliable is he?
He's not super reliable.
Okay. I don't really want you driving at all outside of the work stuff. It's all supervised, but I'm not going to make you lose your job over this. I know the public transit in this county is kind of atrocious. So what we're going to do is suspend a driver's license with the condition that you can drive to and from work. You can do the essentials. But for everything else, it's going to mirror your house arrest. You cannot be outside of your residence. If you have a religious accommodation you'd like, you go to church, synagogue, something like that, let the clerk know. We'll work that out. I absolutely don't intend to prevent you from doing anything like that. The key here, ask before you do it. And I don't want to hear any more stories of, oh, well, I was on my way home, I had permission, but then an hour and a half later, I happen to find a field full. Because I'll be honest with you, I don't really know what happened there. Maybe you do have the eyesight of a hawk or something like that. I don't know what to think. But if it happens again, we're going to have a problem. And it's probably just going to be a whole relocation. Your probation served the original sentence plus some penalty time. So please don't make me do that. I'm giving you a lot of chances here. I could have done what Mr. Pearson asked and just thrown you in jail and been done with you. And it would have been their problem at that point. I don't want to do that. You seem like you're trying to figure things out, maybe a little slow, but you're getting there. So if I do all those things, are you going to listen this time?
Yes, sir.
To those questions, you'll get a copy of the order. You can go have a seat and talk to your attorney or take off and take care of your business. The suspension, I am letting you know, it is going to be effective immediately. So if you drove here, you should not be driving back. If you need an exception to drive to court in the future, this is something that I said, before, you need to reach out ahead of time and get that approved.
Okay.
All right. Try to take care of yourself, man. I don't want to see you back here and have to have this whole conversation get even worse. I want to kind of see you come back here next month, do the tests, not hear anything bad. Maybe have your boss from sanitation come by and tell me that you're a good worker or something like that, and then we can get you on your way. What I am going to do, though, is, and this could change in the future, but I'm going to extend your probation by 3 months. So it's supposed to end in January, so now it's going to end in April. You understand?
Yes, sir.
All right, that'll conclude case 0124, probation violation, Jose De La Cruz. Appreciate your time, Mr. De La Cruz. Be careful.
Thank Your Honor.
Yes, sir.
Thank you, Your Honor.
Your Honor, one matter of housekeeping. There is an active probation case 0081. Probation has lapsed in that matter. We are prepared to have that matter closed. It looks like it was just missed by the court staff.
No reports of non-compliance on that one.
No, Your Honor, appears to be in complete compliance.
All right, that one, 0081, is closed. And 0082, are you looking to do the same thing?
Allow me one moment to check that probation end date, Your Honor. Yes, I missed that one. Pardon me, Your Honor. I missed that one in my review. I thought it was supposed to end in December, but it appears it's supposed to end November the 5th. My reports indicate absolute compliance as well. 0082 is welcome to be closed.
So ordered. What do we have? Actually, we'll take a brief recess here just for a minute. I know the court doesn't have the most accommodating facilities, but should you need to use the vending machines or whatever in the lobby, please feel free. We will reconvene in just under 5 minutes here.
Thank you, Your Honor.
All rise.
Oh, my goodness.
Why can I sit back down? My knees are hurting.
I'm telling you.
Why are we standing?
Give me a run for my money, Mr. Pearson.
Yep. Thank you, Deputy. So you're tracking the suspended sentence, right? So he has imposed 6 months jail on him if he violates.
Yep.
Yeah. Okay. All right. Well,
Yep. But I mean,
what's up, Brian? I'm good. How are you?
Hopefully.
Look, I'm rooting for the guy, right? I just genuinely don't think he's a good candidate for probation. Four. Count them. 1, 2, 3, 4 citations. I rarely show cause for traffic infractions, but I'm not going to change that. All right. If he gets a new, he'll be arrested if he drives again. So I mean that's kind of the caveat there. I don't intend to show cause him for a new speeding ticket. The problem will be that he'd be driving under suspension. So
yeah, I mean,
or if per se he gets one, if he's traveling as he's supposed to, like to and from work.
Yeah, I got you.
I don't intend to show cause on that, but I just want to remind you that I can and I could.
I have had that conversation with him. We stepped outside. At this point, due to the grounds and how tight of a leash he has around his neck, I don't feel that my client's going to reoffend again. I think.
I sure hope not. That's the whole point here is public safety.
I am fighting for him as much as I can, but you know, we'll. I've done everything I can. Ultimately, at this point, what happens next? That's.
Do you intend to continue representing him until the end of probation, or are you gonna withdraw from the case?
Nope, I will continue fighting for him all the way through.
Okay. If I start to notice things, I will reach out to you just as a courtesy prior to filing any additional paperwork in the future if something comes up.
Perfect. You got my my email and my company phone number as well, and personal.
Yes, sir.
Okay. Yep. Feel free to reach out. I mean, you're aware of the office hours down there. pretty
Yeah.
much open anytime, even if I'm on the golf course. So feel free
Perfect.
to reach out to me.
There is a traffic case on that you represent on. I think it's 0110. It's set for trial today. Obviously, I don't represent the state per se. I believe Deputy Stolas is on that one. He is here today. He has a.
I do believe that was moved to the next docket due to a lapse of some time delegations.
Okay, I was gonna say
Abortions.
we are missing. I wouldn't say a key witness, but we are missing a witness, Lieutenant Mike
Yes.
Simon. But in theory, that could have gone forward today. But if you don't have a problem setting it over, I'll just get that called on the record.
Well, my client also had some obligations that he had to attend to.
Oh, perfect. Okay, we'll get the judge to reset that.
Yep. But I do believe, I think we spoke briefly during a meeting call earlier, that is to be set forth on the December docket.
December 8th. Yeah, perfect.
Yes. Yes.
Okay, I'll get the judge to call that in the record, and then I think that's it for you, right? Nothing else?
Yeah, I'll probably just sit in.
Perfect.
You never know what might pop up.
You never know. All right, Mr. Stewart, pleasure as always.
Yep. Man, you gave me a run for my money. I'll give you that.
I appreciate it. Alrighty, folks, we have I think 3 or 4 cases left to call, so we will get those done up as soon as possible. $17 likes. Hell yeah, guys. Let's keep it up. Appreciate y'all.
Let's go in and change.
Do you have anything on the docket today, Mr. Zimmerman?
All rise.
You may be seated. All right, gentlemen, we're next going to call the case of Mr. Malone. He's in custody, so bailiff, will you have one of the deputies bring him up from downstairs? All right, Mr. Malone.
Yeah, bruh. Where do I stand, dude? Right
You're
here?
going to go table. You're going to have a seat over there. Deputy.
Oh, okay, dude. There's no
Mr.
seat
Malone.
at this table, bro.
Mr. Malone.
Where do I sit? On the ground?
Mr. Malone, if I have them
Yeah?
take those handcuffs off you, are you going to cause problems in my courtroom?
Bro, I never cause problems, dude. It's like I'm innocent and shit, and
Okay,
that's why
I don't want you to talk about the case. I just want to know
okay,
right now,
dude.
are you going
I
to cause a
can't
problem?
prejudice the jury guys back here and that shit. That's
Okay,
I
we're
get
not
you,
at
bro.
that stage of your trial, sir.
What? Okay.
There's no jury
So-
today.
No? Then who are these bros?
That is the gallery, and if you could refrain from addressing them, I would appreciate it.
Okay, bro.
So, bailiff, go ahead, take the handcuffs off him. Just hang tight with him in case he decides to get out of line.
Understood, Your Honor.
Oh, that's a lack of trust and shit, bro. You
I could leave the handcuffs on you, but first of all, no jury. But I'm trusting you not to misbehave by letting him take the cuffs off at all.
Okay, bro.
You have quite the story here, sir. So we're gonna get into it in a minute. But
okay.
no, right where he's standing, you're gonna take a seat behind there.
Mine there. Oh, this
Behind
one. Oh, I got you, bro.
Yep.
Okay, you got my
Relax.
files and shit here. Okay, I'll read this. Okay.
Stay silent, alright?
Okay. But how am I gonna plead my case?
When you
For
guys just
silence.
speak, silent.
Oh, okay.
All right, Mr. Malone, a couple things for you today, sir. Is your first and last name legally Tommy Malone or is it Thomas Malone?
It's Tommy, dude. Tommy Malone.
Okay, Your Honor is fine, sir, but not dude. We're in a courtroom. Just
Dude.
please act respectful.
Oh, okay. Wait, which one do I say?
Your Honor.
Honor. Yeah, that sounds official. Okay, Your Honor.
All right. So, you have a couple things that I want to remind you of. You have the right to remain silent. You have the right to an attorney, which I notice you have chosen over here not to have one with you, but you do have the right at any time to request one. If you qualify, you can be appointed one at no cost to you. Anything you say here, anything you do here can be used against you in this proceeding or in other proceedings in the future.
Okay.
Do you understand all of that?
I understand, Your Honor.
All right. So we're going to start with an indictment here.
What does that mean?
Basically, what's going to happen is I'm gonna get into the specifics of your case, but I gotta talk through some things with you because you don't want a lawyer.
Okay, well, yeah, I don't want no lawyers. Court-appointed guys, they don't care about nobody. It's got like a million cases, and I'm just a number. But I know the law because I watched like a dozen, maybe 2 dozen episodes of Law and Order. So I got the court stuff down. I can do this, bro.
All right, just bear with me here. We gotta go through a couple things. You know how paperwork is.
Yeah, dude. Yeah. I hate
Okay.
paperwork, dude. It's the worst part of like rolling the
All right,
coins
just
and stuff.
it's over with.
Okay.
You have indicated that you have a desire to give up your right to an attorney in this matter and represent yourself, and you do have that right. But before we proceed, I'd like to discuss with you the risks of going forward without an attorney. First, I need to ask you if you're under the influence of alcohol or drugs.
No, bro. I'm good.
Are you suffering from
Sorry,
any
Your
injury?
Honor. I'm good, Your Honor.
Okay. Are you suffering from any injury, illness, or disability of any kind that could affect your ability to think or to make a rational decision?
Well, that girl in high school who was like a shrink thing said that it was like mentally illnesses, but I don't agree. And so I want that to be stricken from the record, Your Honor. In fact, I objected the fact it was brought up at all.
So you're telling me no, you don't suffer from any of those things?
Huh? No, I'm not a sufferer, bro. No,
Okay, then
Your
yes
Honor.
or no?
Your Honor. No, Your Honor.
All right. You have the constitutional right to the assistance of an attorney. If you can't afford one, this court will provide one for you if you meet certain conditions established by the Public Defense Services Commission. To determine if you meet these standards, you'll be required to provide financial statement of your assets, debts, incomes, and other information. Do you understand that you have the right to an attorney, including one provided by this court at no cost to you if you qualify?
Yes, I understand that, bro. Wait, what was it again? Your Honor.
All right. Do you have enough money to hire an attorney yourself?
Right now, I don't have any pockets in this outfit I'm wearing,
In your bank
bro.
accounts anywhere accessible to you, gold bars, Krugerrands?
Oh, no. No. Your Honor.
Okay. All right, so I'm going to explain a couple things to you. We're going to talk about some of the statutory maximums. I don't know if you're familiar with the term, but it means the most that the law allows me to impose as punishment for what is alleged that you have done.
Okay, sounds pretty straightforward.
Your first charge is going to be assault with a deadly weapon. It's a violation of section 245, subsection A, subsection 1 of the Penal Code. It's alleged that you committed an assault upon the person of another with a deadly weapon or instrument other than a firearm, I believe. Let me double check that.
Yes.
Deadly weapon other than a firearm. Okay.
That's
Count.
I plead that's not guilty.
Okay, hold on. I'm gonna give you a couple protections that we would necessarily have a lawyer for in other cases. When you say stuff like that, we're gonna strike it from the record because I don't want you to admit to something when you're not trying to. Remember when I said anything you say can be used against you? I mean it. So please be careful.
I didn't say I didn't do nothing. I'm not. It's not guilty.
Okay. We're not asking for your plea yet. I'm just explaining to you some of the things that are possible by your charge. So the first charge that you have, the assault with a deadly weapon other than a firearm, is punishable as a maximum by imprisonment in the state prison for 4 years, or a county jail not exceeding 1 year, or a fine not exceeding $10,000, or both. Do you understand?
Objection, Your Honor. I didn't do that.
There's no objecting. Do you understand that that is the maximum possible penalty I can impose upon you for that violation of that alleged violation of the law?
Oh, I get it, Your Honor. I understand. Yes, I get it.
Mr. Pearson, looking at 11,350 on count 2, why are we charging that one as a felony? What was the related narcotic there?
Give me 1 second, Your Honor.
Ooh, Your Honor, I know this one. Your Honor, Your Honor, Your Honor, but I know this one. I know this one.
Hold on, Mr. Malone.
Oh. That sucks.
Just taking a quick peek at the arrest report here, Your Honor. And it is a log. The alleged controlled substance, Your Honor, is cocaine.
Essentially simple possession of cocaine.
I'm verifying that right now if we have a wait in here. That is correct, Your Honor.
Okay, so just looking at what I have in front of me here, I just want to confirm that the state is still intending to press that as a felony.
Let me see here. I had one of my assistant DAs draft this. Based on my review, it looks like allegedly the defendant was in possession of more or less paraphernalia. So the state, after court today, will file an amended charge. We'll be changing it from possession of controlled substance to possession of drug paraphernalia.
What?
Yeah, so
Objection! You can't change it after the fact, bro. It's like
It's
that's
a
cheating,
superseding
dude.
indictment, sir.
He's
It's-
cheating. That's
I can
not
explain
fair.
it to you if you want, but he's allowed to do that.
Oh, how you explain it? It sounds like cheating to me, bro.
So he's changing the charge that the state is pressing against you, which means that there are now different penalties attached to it, and they're alleging that you broke a different part of the law.
What? But cheater. He's a cheater, Your Honor. I would like that on the record.
Your Honor, if I may.
Are we doing another count of paraphernalia, or just keep that one and striking count 2?
Striking count 2, Your Honor. But, Your Honor, if I may make a statement here.
Sure.
Based on the defendant's presentation, I'm concerned of his abilities to aid and assist in this case, and I believe that a mental health evaluation may be required under San Andreas Penal Code 1369.
Objection. I think that about him. What he said about me, but about him.
Mr. Malone, do you understand what he's saying about you there?
It didn't sound good, Your Honor. But, it didn't, so rubber and glue, it's him. He's the one who can't aid in his defense. Yeah.
Okay. And are you seeking a finding of mental incompetence as to the reason that you're being allegedly charged, or that you're being charged with these crimes?
What? Because he's mentally incompetent?
No, sir, you, as the defendant.
No, dude. No, objection. No, bro. I am totally... What's the other one? Competent. That's the one. I'm that, bro. Your Honor, sir.
Okay. So what we're going to do is we're going to continue for now. We may have some doctors take a look at you, just given a few concerns, make sure we get everything covered, because I want to make sure you understand that
Your Honor.
my
I
whole
don't
job
like
sitting
doctors.
I'm sorry, but you're going to have to talk to at least 2 of them, it sounds like.
I don't like that.
I hope you understand that me doing that is not to make you have to talk to somebody you don't want to. It's that I'm trying to protect you from all of the things that our Constitution, both on the state and federal level, guarantee you the rights to do. And one thing we really don't want to do is find somebody criminally responsible when maybe they had something going on in their head that makes it impossible.
What sort of things? Wait, do you mean if I am incompetent that I'm didn't do anything wrong?
No, it doesn't mean that. It just means that there's reasons that are especially applicable because of whatever the condition might be. So you would probably, in that case, be required to spend significant amount of time in an inpatient psychiatric treatment program, if that was the case. I'm not saying that it is.
Oh my God. Is that like one of those rubber rooms places? No, sir. I object. I object, Your Honor.
All right, so like I said then, we'll proceed for now.
Let's do that.
We'll proceed for now, and we can look into whether or not we need to make those appointments to talk to you while you're being held here. Has that been okay to you in the jail so far?
It's not too bad, but the guy down there, he's over there now, the bald one. He wouldn't give me a smoke, so it's like against my rights and stuff. Cause I got a right to a smoke before I come out here and do my trial and stuff, but he wouldn't give me one. And then he ate a donut right in front of me. He didn't offer me a piece, so I'd like to report that on the record, sir.
Okay, well, everything you say here is on the record, so that is now on the record.
I just want to make sure the jury knew about that.
Okay, so we've stricken at the state's request count 2, the possessed controlled substance felony.
Wait, what does that mean?
So basically, you don't have to worry about count 2 anymore. That one's gone.
Wait, does that mean I won that
one? No, it just means that the state's not pressing that charge against you at this time. They could do so
sounds
in
like
the future.
A win. That sounds like a win. I did. You see, my first win as a lawyer. I did it. Oh, this is awesome. I got a party.
All right, so the next one that you're facing is violation of Health and Safety Code, Section 11364, subsection 8, HS. That's to possess drug paraphernalia. That's any instrument that's used to inject or smoke a controlled substance.
Objection. I have never used an instrument to smoke crack. Because how would I even do that?
Okay, so the maximum penalties for that crime are up to 6 months in the county jail and a fine of up to $1,000.
I did not smoke out of a trumpet, bro.
Okay. I'm going to take that as you understand what the penalty is. Is that a fair assumption?
For what? The trumpet smoking?
That if you are convicted of the offense of possessed drug paraphernalia, that you'll be sentenced to at a maximum 6 months in the county jail for that offense and a fine of up to $1,000. Keeping in mind that those penalties can run together with the other offenses that you've been charged with. But for that offense, the maximum is 6 months and $1,000 fine.
Okay. I would like to speak with the judge afterwards about what law that is, because I did not know that you weren't allowed to smoke out of musical instruments, but I don't think I did that. It's okay.
We're not talking. We're just talking about what you've been charged with.
Oh,
so that's
okay.
For your reference, since you asked, it's Health and Safety Code 11364.
Okay, I'll look up that one. I don't see that on my papers. Hey, bro, next to me, do you see this on my papers? You got glasses on. You must read good.
Your Honor, the state would like to point out that
Do you have a copy for him, or does he need another one?
He was presented a copy, Your Honor. That being said, I have just filed electronically an amended complaint. Let's see. There is a printer over here. Give me 1 second, Your Honor. I'll print out a copy and provide it to him at this time.
All right. then you understand that as it is right
thank
now,
you, dude.
there is a charge there that alleges that you trespassed. Generally speaking, that's going to come because you went somewhere after you were warning not to trespass, meaning you can't return upon or stay on or be on or approach upon the lands of someone who has formally requested that you not return there.
Your Honor,
No.
in
Bro,
this
can you
matter,
read
the
this?
allegation is essentially trespassing upon private property that he had no right to. Under the penal code, as it's understood by the district attorney's office, there's no expectation of a landowner having to order somebody not enter their private property. So that is the subject of the trespassing charge here. I believe the criminal complaint lists a specific subsection of the penal code.
I see. Okay, we're looking at 602M. All right. So, with that in mind, so the penalty for trespassing thing can be imprisoned in 6 months, a fine not exceeding $1,000, or both by that fine and imprisonment. You understand?
Yes, Your Honor. I'm guilty on that one. Guilty.
We'll strike that from the record. I don't want you to tell me if you're guilty or not guilty.
Oh, okay. Oh, I remember that now. I'm sorry, dude. Neutral. Your Honor.
Okay, fair enough. So, you understand that all those sentences that I mentioned, the maximum possible sentences, I'm not saying that you will receive those sentences, but it is possible. Those sentences could all run concurrently or consecutively, meaning you could serve either the longest of the single offenses with which you've been charged if you're found guilty, or a combination of all of them. Do you understand that?
Yes, Your Honor.
Okay. Certain mandatory minimums can apply. I don't believe this case involves any. So we'll go past that part. And then there's a few other consequences I want you to be aware of. I know you have a bit of a history, but it's worth explaining again. At least one felony in this case. A felony entitles that you are disqualified from exercising certain rights normally granted to a citizen of this country. You can't own a firearm. You won't be able to vote during the certain periods of your supervised release or incarceration, depending on how things go for you.
Okay, well, I don't vote anyways, bro, and I don't have a gun, but I didn't do no felonies. Everybody know that.
So, by choosing to proceed without an attorney and to represent yourself here, you're at a serious disadvantage. And here's why. You lack legal training. For example, you may not realize that you have one or more defenses to the crimes to which you are charged with. You lack experience with the rules and procedures that this court will apply to you, even though you're not a lawyer. The state is represented by an attorney and does not have these disadvantages. In a sense, the state will have an advantage over you in this case. By choosing to proceed without an attorney, you're giving up the following benefits. An attorney can review the facts of your case and discuss them with you to determine what defenses you may have to the charges against you. An attorney can also identify problems with the state's case against you. An attorney could also advise you on how to plead to the charges against you and, if appropriate, assist you in entering a plea deal. An attorney can help advise you on whether you might qualify for release from jail before trial. If you choose to plead not guilty, an attorney would prepare your case for trial, including gathering evidence, interviewing and subpoenaing witnesses, preparing to cross-examine the state's witnesses, and filing pretrial motions. Additionally, an attorney knows the rules and procedures involving discovery, that is, how to get information from the district attorney that's important to your case, like police reports or witness statements.
I don't need any of that, bro. I
An
don't
attorney
need
can
it.
make legal arguments to the court during trial and present opening and closing statements to the jury. If you choose to proceed anyways without an attorney, you will not be able to rely on the judge, court staff, an interpreter if you needed one, or the district attorney for legal advice or any assistance in defending yourself at trial. In light of this information, do you understand there are disadvantages to representing yourself?
Yeah, I see him as advantages, bro, but, Your Honor, but, I'm cool with it. Let's rock
So
and
is that a
roll.
yes?
Yes.
Explain to me in your own words some of the disadvantages you might face if you proceed without an attorney.
0, because I'm great at this stuff, so I've got advantages. I mean, look at this guy. I can totally beat
Okay,
him.
some of the disadvantages I told you might face.
Oh, I got you. That, give me 1 sec. That they know more, defenses than I do. But
Okay, I'll accept that
that's
answer.
not true. It's not
Do
true.
you have any
though.
questions about the information I just shared with you?
Give me a sec. No, I'm good.
Has anyone encouraged you to proceed in this trial without an attorney?
This one dude down at Bolingbroke, he said that it might be cool to do that, and then I thought, well, you know what? You're right, bro. And so he encouraged me as a friend does, But that didn't count, right? I don't know. Does that count?
Okay, can you please stop calling me dude or bro or whatever?
Oh, sorry.
Normally
sir.
at this point, other people in your shoes would be in trouble, but I'm trying to give you leeway to go through this process because you are defending yourself in a felony case, okay?
I got you, Your Honor. Your Honor. Thanks, bro. You're a great wingman.
Has anyone threatened you with any form of punishment if you choose to have an attorney?
What? Well, you guys are threatening me with punishment, right? So.
If
Yeah.
you choose to have an attorney.
Oh, sorry, bro. Your Honor, I just listened to the first half of that sentence and not the second. No. Yes. No.
Okay,
Yeah.
I'm gonna
what's
tell you
right
this.
answer?
Now that I've given you several warnings, if you do that again, if you call me bro or your buddy or whatever, anything that's not appropriate for court, I ain't gonna hold you in contempt, and it's just gonna make things worse, okay?
What? But I like you.
It's not appropriate and it doesn't show respect for this court. It's not just me, it's the court that I represent.
Okay.
Okay. Do you still wish to proceed without an attorney and represent yourself now?
Yes. Yes, I do, sir.
Explain to me in your own words why you don't want an attorney.
Cause I don't agree with these court appointed dudes, cause they got too many. Wait, can I call other people dude or just not you?
Just not me.
Okay. I don't agree with these court appointed dudes, cause they got so many cases and stuff. They're not even gonna help me none more than I could myself, because I got all the knowledge from the TVs and things. It's I watched some Law and Orders and some Judge Judy's and Dr. Phil, which also helps. And it's I may have been half buzzed most of the time, but I feel like I retained enough to do better than these stuffed shirt guys who have all these different cases to look at. This is me. I can defend myself best, right? Of course. And of course, obviously, it's my my right too, right? Because like this dude down at Bolingbroke, he told me all about this Constitution thing and how like I'm like allowed to do that because like it says
All
so
right,
and all that
that's
stuff.
fine, sir.
Oh, okay. Thank you, Your Honor.
All right, so what I'm going to do is I'm going to have the bailiff bring you a written waiver of counsel form. What I'm also going to do, so you're going to sign that form. That's just basically saying, yes, I understand. I don't want a lawyer. Had all this explained to me. And I'm also
Okay,
going to appoint
I'm not great at
standby
writing
counsel
stuff
for
though.
you. All right.
I mean, can he write it instead?
No. If you don't, I'm going to be forced to appoint a lawyer for you, and I don't think that's what
Okay,
you want.
No, I think I can manage it. It's just I haven't written much in a long time, so it's probably like not gonna be great handwriting and stuff. Does that matter?
No, that's fine. As long as it's your closest estimate at a signature there.
Oh, gotcha.
There you go, if you want to hand him that.
Thank you.
Oh, you the one who wouldn't give me the donut, bro. Thanks, though. Thank you.
You're welcome, sir.
Let me see. I got some pen right here somewhere. Yep, there's a pen. Let's see. So, okay. Wait.
Right there at the X at the bottom. See, it's got your name on the top. It's got today's date. It's got the case number. At the bottom, there's a place for you to sign. And again, I'm reminding you, if you need help reading it, we can get you somebody to help you read it. This be a waiver of your right to counsel.
No, I don't need to read it. You told me what's in it, Your Honor. So, you know, I'll just sign it right here. See, that's the old Hancock thingy. Yeah, there we go.
All right, and then bailiff, just bring that in front of the defense, or the state's attorney, just so he can witness as well that that does have a true and correct signature on it.
Yes, Your Honor, that appears to be correct.
Okay, we'll note that for the record. Bailiff, bring it back to me, please.
Here you are, sir.
Thank you. All right. So, for the record, the defendant, Mr. Malone, has been informed of the dangers and disadvantages of self-representation, as well as the benefits an attorney would provide, and knowingly, voluntarily, and intelligently waived his or her right to counsel, pending the outcome of a mental health evaluation. Should they find him competent to stand trial, then I will accept his knowing waiver. All right, Mr. Malone, we're going to proceed then. So you do not have a lawyer. So you are charged with a couple things. I'm going to read you. You have the right to remain silent. You have the right to have an attorney present. Even if you cannot afford one, anything you say here can be used against you in this proceeding or in future proceedings. You understand?
I understand, sir.
Okay, charge count 1, as I explained before, assault with a deadly weapon other than a firearm. That's a felony. Carries with it 6 years in the state penitentiary as a maximum penalty, $10,000 fine. As to count 1, assault with a deadly weapon other than firearm, how do you plead?
Not guilty.
All right.
I nailed that, dude.
As count 2, that on or about October 24th, 2024, you did knowingly and unlawfully possess paraphernalia related to narcotics, not related to cannabis. How do you plead?
What does that mean? What? I don't understand the word. There's a word in there.
Okay, I'm going to enter a not guilty plea on your behalf at this point.
Okay, that sounds good. Wait. What? Just tell me what paraphernalia is, and then I can help you.
I am not your lawyer, and I explained to you this is why you should get a lawyer, and you still can if you want one.
Oh, okay. Not guilty.
All right. Count 4, or count 3, excuse me. You did knowingly and unlawfully on or about October 24th, 2024, unlawfully trespass upon a property that you had no reasonable right to be on without permission or consent of the rightful owner. How do you plead?
That guilty. That's guilty. Yeah.
You wish to plead guilty?
I do, sir.
Okay. I'll accept your guilty plea on count 4 pending the outcome of that mental health competency evaluation.
And the state would move to set over sentencing for the defendant's guilty plea until the outcome of all charges.
Yeah, we'll hold it together. Mr. Boone, what happened on October 24th, 2024? This part here, again, I wouldn't explain this to you. Normally your lawyer would do it for you. This part's an allocution. You're going to tell me what you did so that I can accept that guilty plea for you. Because if you plead guilty to something that you didn't do, that doesn't serve the interests of justice at all, and I'd rather be sure. So it's alleged that on October 24th, 2024, in this county, Los Santos County, that you did unknowingly and unlawfully trespass on a property you had no reasonable right to be on. Tell me what happened that night, or that day.
Well, that was a night that I was out getting some cash on the streets, with some people that were, giving it to me up on the boulevard, those rich people and stuff. And I went up there and I was doing that for a while, and then boom, bang, there's a big storm that happened, and it was loud, and there was lots of rain, and it was getting cold and stuff, and I didn't have no very heavy coats or nothing, and I was like, well, I need somewhere to go so I don't get struck by lightning or die or something, or a car might hit me or something. So I rode around on my bicycle and I looked for somewhere I could get some shelter and stuff. And I seen this one place that had some shelter, and I went in there and I bunkered down, I went and I slept and shit. And what happened then? Oh, I was sleeping, and I was sleeping more, and I was dreaming some. And a dude comes in, and he shoots me for nothing, bro. And then the rest of the cops and stuff, they roll up.
All right, hold on. Before you start talking about your other charges here, just specifically as to the trespassing, you entered that property knowing that you shouldn't have been there.
Yeah, but I thought, my life might be in danger and stuff to stay out in that terrible weather and stuff, and I didn't have nowhere to go, and I'll shout.
Okay, so again, this is something that I wouldn't normally explain to you, your lawyer would, but that is a defense. It's an affirmative necessity defense that you could raise by pleading not guilty or guilty and taking this case to trial.
Really? Huh. I thought
Do you still wish to continue with your guilty plea?
Oh, but I don't understand. Yeah, I'm guilty, bro. I did that one. I guess I shouldn't have been there and stuff.
All right. Court will take note of that. As to the other charges, what does the state recommend as far as bail conditions here?
Your Honor, while the state respects the defendant has not been convicted yet, the allegations of assault with a deadly weapon other than a firearm are concerning, and I have a fear, and now that we have a guilty plea, albeit sentencing is set over, my concern for public safety and the defendant's actions are gonna, it causes me to request bail, and I'm gonna request bail be set in the amount of $50,000. With 10% approved, obviously meaning he would only need to post 5,000 of the 50 to be released.
Okay.
Is it serious?
Do you have an answer to that?
I don't like it. It doesn't sound good.
That's not what I mean. Do you have a different answer as to conditions under which I might release you from custody?
Oh, if you could just let me go, that'd be awesome.
Just let you go, no conditions, nothing.
Yeah, well, that'd be nice. But I'd be willing to accept some if I had to go and talk to someone or something. I know I've seen that on TV where they go and they like check in with someone and say, well, I've got a job here doing this thing. You know, that guy. I'll go and see him.
Your Honor, it sounds to the state like the defendant is talking about a probation and or parole officer, and we're not permitted to place him on probation or parole until he's adjudicated.
Oh, that's no good. Well, oh, I seen this in TV
Mr.
too.
Malone, here's what we're gonna do.
Oh, okay. You got a suggestion? Go, bro. Oh, sorry, Your Honor.
I'm making it really hard for me not to hold you in contempt here, sir.
It's like honest mistake. It's the way I talk, and I'm so sorry.
Okay, so here's what we're gonna do. I do have a couple doubts about your ability to represent yourself correctly at a trial. Serious penalties attached to these charges. So what I'm gonna do is I'm gonna order you stay in the custody of the sheriff's office for such a time until at least 2 board certified either doctors or psychiatrists are able to speak with you and complete a competency review. They're going to decide whether or not your mental condition is such that you can, with either assistance of counsel or as you requested on your own, continue in this trial. What I'm going to do after that point is going to depend on their recommendation, but honestly, you attempted to attack someone with a machete. I have those concerns about your awareness of your surroundings in general. I find that you're a danger to the public. And so for that reason, I'm going to set your bond at $15 million cash.
What? What? Huh? It's crazy. Huh? I
You
didn't have that,
attempted to
bro.
attack someone with
Sorry.
a machete, sir.
I
And
did not.
you just
I'm
called
not
me bro
guilty.
again.
I said not guilty on that, dude. This is bullshit. Your court is like,
He's
what's
in
your
contempt.
name, dude?
You can put handcuffs.
What's your name, bro? I want to know.
Stand down.
Oh, you guys suck, bro. Ow. Jury, don't
Arrest the one
hold it
who's
against
clapping,
me.
too.
That's unfair, man. Hey, you're free. I believe me.
Yeah,
I believe you, man.
Thank you, dude. Thank
got you.
Justice for Tommy, bro.
Woo,
Justice for
for
Tommy. Justice
Justice
for
for
Tommy. This is bull crap, bro.
Turn around.
Arrest me.
Hands behind
No,
your
I
back.
think
Turn
you're talking
around.
about
Turn
somebody
and face
else.
away.
It's an
Okay.
international conspiracy. You're a Dutch guy. I know it. You
Yep.
came
Freak the
from-
Dutch
All right,
guy,
Mr.
man.
Malone, we'll see you another day.
Damn you.
Woo! Justice for Tommy. Come on, guys.
Jeez.
Everybody, justice for Tommy. Justice for
grab him?
Tommy. Justice for Tommy. No,
Sir,
no.
stop it. This is
Oh,
a
sorry.
courtroom. You need
Sorry,
to be
Your
respectful.
Majesty. Sorry, Your Majesty. It's my first time. Woo! Justice for Tommy.
You're gonna go sit in the
Justice
basement. You better
for
stop.
Tommy.
If I hear that you keep doing that, I'm gonna send you to jail.
Sorry, Your Majesty.
All right. Well, obviously, with that happening, we're gonna hold that in abeyance. Basically, is going to stand. I'm open to reducing if he can prove ties to the community, any kind of actual plan as to his treatment. But he doesn't have a lawyer here, so we can't really do much else at this point. So we're going to hold that over. He's going to remain, for now, just on a contempt charge.
Thank you, Judge. Your Honor, did we already set over that traffic case?
0110. No, I don't think so. Let's do that.
Thank you, Your Honor. Both myself and Mr. Stewart are in agreement about setting over case 0110 to December the 8th.
That works by me. Do you know the defendant is okay with that? Have you talked to him at all? I don't think he has a lawyer in that case.
He
Your
is
Honor, I am-
represented by counsel.
Okay. Mr. Stewart, no objection?
No, Your Honor. I had been in contact with my client prior to today's docket. Due to some unfortunate events, he was unable to make it to today, and it was under the agreement that
Okay.
we'd move it.
I mean,
to
no
December.
objection either party. I'd so ordered.
Thank you, Judge.
Thank you, Your Honor.
Bailiff, will you ask the deputies downstairs what that gentleman's name is when he was clapping?
Yes, sir.
All right, so 0110 is rescheduled. Let me make a note of that.
And then, Your Honor, as my records indicate it, I believe we only have... There are only 2 cases left in the docket. We do have another in-custody case, 0113. I believe that is just on for arraignment. The defendant is represented by counsel. He just needs arraigned on the record. Beyond that, I think there's a civil case where Mr. Stewart represents an individual. I believe that, just from the notes I have, that case is on for a preliminary hearing.
All right. So we'll do the in custody, and then I might have a chat with this gentleman who was clapping here real quick.
Certainly, Your Honor. The state does want to request that the defendant in 0113 remain in restraints. It was reported to my office by sheriff's deputies that he has been loud and aggressive with other inmates. He's non-compliant with deputies as well.
All right. So before we have a chat with him, let's bring the guy up who was clapping. I'm going to have a chat with him.
You want the gentleman that we took down? There's your...
The one that was in shorts, yeah.
Wait, I was just joking, man. I don't want to go to jail or nothing. Go through this door, man? How you doing, sir?
It's your honor.
Oh, how you doing, Your Grace?
It's your honor.
Oh, sorry. Sorry, Your Honor.
Okay, there you go. What's your name?
Gary McDougal the Turd, sir. At your service.
Ms. McDougal, why do you think it's appropriate to start clapping in a courtroom?
I'm sorry, man. I just don't think it was fair what you did to Tommy, man. He said not guilty. He's not guilty, sir.
Okay, so you understand that the courtroom has decorum. Can't do that. If you disagree with me, first of all, you don't have any say because it's not a case involving you, but he can appeal it higher if he disagrees with my decisions.
Well, we just were talking about it, and I think I'm a representative in court, sir. He seems like a good young fella.
Are you a licensed attorney?
I got a driver's license, yeah.
If you're lying, that's a crime, just so you're aware.
Oh, no, I plead the fifth, sir.
Okay. So, how about this? I'm gonna fine you $100 because that was ridiculous and you should know not to do that in a courtroom. But
I'm sorry,
I will
Your
let
Grace.
you sit and watch the rest of the proceedings if you would like. If you do anything like that again, and I hear you calling me Your Grace and all this, just sir is fine.
Oh, okay, sir. Can I give you? I got $62 in my wallet
Money
right
does
now.
not go to me. The money goes to the clerk of the court.
Oh, okay, sir.
So if I have you pay that fine, will you sit there respectfully, or are you going to cause more of a problem?
I will be respectful, your sir, and I will no longer clap for the injustices in this court. Sorry, I retract that last statement. I will no longer clap at all, and I will be respectful and sit down next to that fella over there with the brown shirt. And I won't say nothing.
You could take him. He's going to spend the night with you guys.
What, sir?
You're just not stopping. You're saying what I'm doing is injustice. We're not doing that in my courtroom. You're going to jail.
Oh, rip.
My lord, please. I beg you. I will pay the $100, and I will no longer be disrespectful and be mean in your courtroom, sir.
Okay, I'm going to give you one chance, and you're still going to pay the fine, but now it's $200. Are you going to go sit there and be quiet?
Yes, sir. Please don't make it no more. I don't got too much money. I spent all my money on this suit.
I mean, it's not just the money, too. You're going to end up spending a night in jail if you don't stop.
All right, sir. I'll sip a lock and put it in my pocket.
Jesus Christ.
All right. You can take him out of handcuffs. We'll fine him before he leaves. All right, and then they said the next one has a bit of a history, so let's get him shackled and cuffed before he gets brought up here.
Your Honor, it's just occurred to me that my team has not yet filed the criminal complaint for Devon Boyd's case 0113. You give me a second, I will prepare the charges and at least advise you of the charges.
Sure.
So be a list of the intended charges once the complaint gets filed later this week, Your Honor.
No, sounds good. Mr. Boyd.
Yes, Your Honor.
How you doing?
Oh, I'm fine. How you doing, good sir? Nice digs you got here.
Yeah, it's not too shabby. How's jail?
It's all right. It's all right. I treat me fine down there.
I mean, it's not supposed to be great, but, you know, I mean, I'm glad it's okay at least. So, what's before we get started here, I mean, we're going to get into the nitty gritty of this, but just real quick here. You doing all right? Is there any kind of counseling or anything that we could be offering you that we're not doing in the jail that might help? I mean, looking at a whole bunch of stuff.
What are you gonna counsel? Man, I'll just get up out of here. What's my bail?
All right, so we'll do it the hard way then. So you have the right to remain silent. Anything you have the right to have an attorney present before any questioning, if you should so desire. You don't have to say anything. Anything you do say, however, may be given in evidence in this trial or in future proceedings. Do you understand?
Yeah.
Do you want a lawyer?
Well, yeah, man.
Do you have enough money to afford a lawyer?
No, I ain't got no money, man. You guys got work for me, though. They told me that.
Well, I got to ask you some questions to see if you're eligible. So what do you do for work?
I'm in between jobs, man.
You got kids?
No, I ain't got no kids.
Got alimony, ex-wife, anything like that? Money you owe?
No, nothing like that, man. No. Man, I just moved out of the city up Toledo with my mom's, man. I just couldn't make it down in the city, so I had to get out of there. So I was staying with her for a while. But I thought I'd get a job at that chicken place there, but
no luck.
I'll get up there one day, man. They probably look for help. I just want to get up out of here, man.
Okay. So how much money is in your bank account?
Oh, man, I ain't got shit, man.
What's that mean, though?
Zero, dog.
You have literally no money to your name whatsoever?
Yeah, man, I ain't got no car, man. I ain't even had a license and stuff, man. I was living on the streets and stuff, but homies wouldn't let me crash on the couch no more, so I moved with mom's.
Okay. All right, so just so you know, at this point, I do believe that you qualify for a court-appointed attorney. I'm going to appoint Mr. Lewandowski for you. His name's Arnold Lewandowski. He's not here today, but he will be in contact with you at the jail. He'll help you formulate a plan there. You're not going to have to pay for that. If you're happy with that, then at least we've got you an attorney. Do you wish to proceed with the reading of your charges and your indictment at this point, or do you want to wait until you get a chance to speak with him?
Let's see what you got, man.
Okay. So we have a bit of a laundry list of charges here, starting with battery on a peace officer. That's a felony. It's punishable by a fine of not more than $10,000 or imprisonment in county jail of 1 year, or depending on the circumstances of the case, 16 months, 2 or 3 years, or by both that fine and imprisonment. Disorderly conduct is a misdemeanor. That means it's punishable by imprisonment in county jail not exceeding 1 year, or by a fine exceeding $2,000, or by that fine and imprisonment. Next, I am looking here. It looks like resist, delay, or obstruct a peace officer in the performance of their duties. That's a misdemeanor as well. Will be punishable by imprisonment in county jail, not exceeding 1 year, by a fine not exceeding $2,000, or by both that fine and imprisonment. Next, substance, specifically cocaine. That is a felony. That's going to be punishable by a fine of not more than $15,000. Imprisonment in a state penitentiary up to and including 2 to 3 years, depending on circumstances, or by both that fine and imprisonment. Next, I see battery, charged as a misdemeanor. Again, punishable by imprisonment in the county jail not exceeding 1 year, or a fine not exceeding $2,000, or by that fine and imprisonment. Criminal threats, misdemeanor, punishment by imprisonment in the county jail not to exceed 1 year, or a fine $2,000, or by that fine and imprisonment. As to count 1, battery of a peace officer, felony. How do you plead?
Oh man, that's not guilty. Not guilty at all, man.
Why are you smacking your foot around? Come on.
No,
Be
no,
respectful.
man.
I'm being respectful to you.
All right, I'll chill, man. But no, I didn't do that. Self-defense, man.
Okay, not guilty then?
Not guilty, man.
Disorderly conduct, count number 2. How do you plead?
Not guilty. It wasn't my fault.
Okay. Resist or obstruct a peace officer in the performance of their duties, count 3. How do you plead?
No, not guilty, man.
Possess controlled substance, namely cocaine, felony. How do you plead?
Not guilty, man.
Battery, misdemeanor. How do you plead?
Not guilty, man.
Criminal threats, misdemeanor. How do you plead?
That's not guilty, man. I didn't do this, man.
All right, I will notate a verdict, or a plea of
It
not
was all
guilty.
set up, self-defense, man. It was a crazy situation. You don't even understand.
Listen, I don't want you to tell me the facts of the case. I want you to talk to your attorney, Mr. Lewandowski, about that because, like I told you, anything you say here, it goes on the record and it can be used by the state, by that gentleman sitting over there against you. I want to protect your rights, but it's important that you understand that when you're talking to me here is fair game. If you say something that he can use against you, so don't do that, please. What we're going to do, we're going to talk in a minute about bail and some other things, but I want to make sure you understand all of those sentences that I read to you. You know, it was a couple of years in the state prison on one of them, county jail. I can impose all of those concurrently, consecutively, or some combination thereof. So that means you could be spending an awful long time in prison. Do you understand?
Yeah, man. Yeah, I know.
Okay. Do you understand that there are serious consequences that follow felony convictions if you don't already have one?
Yeah, I know. My record's clean, man.
Okay, so you understand that, you know, you could lose the right to carry a firearm or possess a firearm, or you lose the right to vote during certain periods of imprisonment.
Yeah, I got that, but that's why I'm clean. I got no history, man.
I'm just telling you what happens if this goes forward and turns out they find you guilty, okay? I just want to make sure you understand.
Yeah,
So,
I got it, man. I got it.
with all that in mind, then, do you have ties to the community?
Man, I just help all my moms around the house.
So, family in the community, at least.
Yeah.
Do you live up in the county here in the city?
Yeah, I'm in Polito, man. You know, Dad died a couple years ago.
How old's your mom?
I don't know, 60s, something, 70s. I don't know, man.
Up in the house, basically, though?
Yeah, she does all right, but, you know, it's not just to help her out.
No other siblings that could help her?
No, it's just me.
Okay, because you're charged with a lot of stuff. And the presumption generally is if I believe there's a danger to public safety by letting you out, that we wouldn't do that. So help me understand what it is that you're going to do if I do let you go out on a bond here, that you're not going to get in trouble, that you're going to do something productive, you're going to help your mom out. I mean, let me know what's going on here.
Yeah, I'm just gonna be chilling up in Mom's house, man. Maybe I go up and get a job up there, Polito, man. You know, I can walk up the road there. It ain't far. Oh.
Okay.
I don't know, man. I'll be good, man.
Okay, I noticed you one of your charges is cocaine there. I'm assuming that means you use cocaine. You don't have to tell me yes or no that that's true, but I am going to order that you take, I'm going to say weekly drug tests while you're in custody and if you're released. I'm also going to order a monitor be attached if you are released. You are to have no contact with, who are the threats against, Pearson?
Your Honor, the allegation as it stands are threats to quote-unquote kill Deputy Stolas while in the performance of his duties.
Okay, well, I can't impose a no contact order on a public servant like that, but Don't do that. So I'm going to add one of your conditions is what I put on everybody. Do not commit any more crimes. That is the fastest way to end up going to jail. Do you understand me? I don't care if it's that they caught you with a blunt in your car when you shouldn't have had it.
Yeah, man. No, I'm cool. I won't be doing nothing.
So if I say that you can post bail, who's going to put the money up? Your mom going to do it?
Yeah, I'll call mom.
And she's got money for something like that?
I don't know. Man. I don't know. Call bail bonds or something. Maybe put the house up.
Okay. You think she'd be willing to do that for you? Because you know that if you skip town and don't come back for court, they're going to take her house.
I'll be all right. I'll talk to mom. She'll be cool with it.
Mr. Pearson, what does the state recommend?
Thank you, Your Honor. State's going to recommend $100,000 bail per felony count. So that'll be a total of $200,000. The remaining counts, the state will request a $10,000 bail amount. The allegation here again, as previously stated, was a threat to kill a law enforcement officer, while obviously it is only an allegation at this time. Additionally, an allegation that he caused a not insignificant injury to Deputy Stolas as well, nearly a broken nose, as my reports indicate.
So we'll add a further condition. You are to possess no weapons, and firearms, machetes, rocket launchers, anything of the sort. Don't care if you had a permit for it before. If you have anything like that, you need to let the sheriff's office know. If you post bail, they will need to collect those and at least hold on to them during the trial. Do you understand that, sir?
Yeah, I got that. I got none of that. No permits,
No
no guns. I got nothing.
No
like
guns? Okay. All right. Here's what we're going to do. We're going to do $200,000 cash or surety. So you can call bail bondsman. They can put down, what is it? I think it's $20,000 in that case.
Yes, Your Honor.
They can do that. They may put their own conditions on you. Bail bondsman will sign the contract with you. Make sure you look it over carefully. You could have your lawyer look at it too if you get in contact with them before they get to you. Don't do that to your mom. Don't have her put her house up for bond and then have you skip town, because that would be an awful thing to have your mom lose her house because her son took advantage of her like that. You're not going to do that, are you?
No, I take care of mom.
All right,
Took
so
care of me.
fair enough. She's your mama. I'm going to trust you on that one. You have to have no contact with anyone that is engaged in criminal conduct or that you know to be a convicted felon. Additionally, I am going to impose a curfew that you not be out between the hours of 11 p.m. and 5 a.m. If you have a job that requires that or something that changes, you can always let the court know and we can work on that. But for now, I don't want you out at night. Bad things happen after dark. I'd rather have you at home. The drugs is a big one. I told you already, you're going to get tested. You're going to get tested a lot. If I think you're cheating on the test, anything like that, you're just going to go to jail. That's all there is to it. There's not going to be any retry this or redo that, this, that. You're just going to go to jail. Same thing with that ankle monitor. I want to know where you are all the time. If it shows you outside your house and you don't have an approved reason to be outside and it's past those hours, going to jail. Kind of get my drift here?
Yeah, man. Yeah, I got it. But when you get a piss test me, I'm probably still hot, man.
So I understand that it still goes through your system for a couple days. So the first one will be a week from today. It may still show some residual positives, but we'll keep testing. That's why I said every week instead of every month, because I want to see that level go down as you stay clean going forward.
Okay, I got it.
Does that make sense?
Yeah.
If that ankle monitor dies, I don't care if you're at a quinceañera, if you're doing whatever, you need to find a way to plug it in. They've got USB chargers these days. It's very easy. It needs to be charged and turned on all the time. You tamper with it, straight to jail. Any of that stuff, straight to jail. You understand me? I'm giving you a huge break here because you hurt a police officer. That's pretty serious. That's the reason your bond is so high, but I'm still giving you a chance. I am not just locking you up and throwing the key away.
I appreciate what you're doing for me, man.
You gonna try to find something productive to do with your life now? Get off the cocaine?
Yeah, man, yeah, it's all good, man. It's all good.
I mean, you got something to say? You want to tell me?
I don't want to say too much here right now, man. I gotta go talk to my lawyer, man.
Fair enough. But, you know, if you need treatment help, you want help getting off the cocaine, anything like that, you just let us know. We will get it for you, and you will not pay a dime for it. The treatment, that is, not the cocaine.
I appreciate the offer. I'm declined at the moment, though.
Okay, part of the conditions, depending on how this goes, is you may be required to complete drug and alcohol abuse treatment. If it comes to that, would you be willing to go through that program?
Yeah, if we need to.
You have any kind of a history of any tickets or anything, and it's all clean?
No, man, I'm clean straight, man. I got nothing behind me.
The state did run criminal history and violations check and found that he does not have a history at this point.
All right. So I'm not going to impose a no alcohol condition, but what I will do is impose a condition that you're not to be under the influence of any substance to the point that you lose control, basically, that you're intoxicated. So if you still want to drink a beer here and there, that's fine. If that keeps you off the drugs, I don't think it's better for you or worse for you or whatever. I'm not saying that, but I'd rather you sit on your couch and drink a beer than, you know, do whatever it is you do with your cocaine.
I suppose I can't go up to that bar, can I?
No,
you're going to stay away from places that serve liquor.
Your Honor, the state would request a condition that the defendant not return to the place of the alleged incident, which is 1045 Doulos Avenue, the Blackwood Saloon.
Yeah, it's like right next to my house, man.
Yeah, the state would request a no return order during the dependency of this case.
What's the street name over there? It's 1045.
It's at the corner of Doulos Avenue and I believe it's Polito Boulevard. We can call it Doulos Avenue, Your Honor. I believe that's most likely the business's registered address is 1045 Doulos.
Okay, so not only are you not to go there, you're not to have contact with any of the employees of that establishment either, you understand?
Yeah, I got it, man. No problem.
All right, Mr. Boyd. So, like I told you, $200,000 cash for surety. So that's $20,000 with the bail bondsman. GPS tether, weekly drug test. You're to stay away from known felons or people engaged in criminal activity. No weapons. You're not to return to the Blackwood Saloon. No contact with any employees of that establishment. Court needs to be notified of an installation of a GPS ankle monitor before you're released if you can post bail, and you're required to remain at your registered home address there in Polito between the hours of 11 p.m. and 7 a.m. unless the pretrial services team gives you exceptions before you do any of those things. Additionally, the standard conditions apply. You may not commit new crimes. You may not possess weapons, etc. You have any questions for me?
No, man, I got it.
Lined up, or you don't know yet? Do you have a bail bondsman lined up, or you don't know yet?
No, I seen some numbers by the phone and the sales, you know.
Okay. All right. Well, I'm gonna enter this paperwork for you right now. So once you get back down there and they transport you back over to the jail, you can start making some phone calls. Maybe even down here in the courthouse, they should have some flyers. Talk to your lawyer. Talk to the bondsman. You should be able to pull this off. You've got a family that sounds like they'll be willing to support you. Don't mess up. Don't come back here and make me look at something that the state shows me that says you did this, that, and the other. Just follow the rules. It's pretty simple. You got a lot of serious charges here. It's a first offense, it sounds like, on all of them. I'm not saying that that's going to excuse anything, but it's going to make life easier. If you follow my conditions, if you don't get in any more trouble, there's a lot of options that open up other than sending you to jail for 6 years or whatever it was. So do the right thing, keep your nose clean, and hopefully the next time negative drug tests, GPS will be all good. No new crimes, nothing to worry about, and we can move on to addressing the charges that you already have. You pick up new charges, it's just like I told you, you're going right back to jail. And this time you're not going to bond out. I'm going to set it so high your head will spin. I just set a guy's bond at $15 million earlier. So believe me.
It's all cleared up. I'll be nice, easy on you. You'll be in and out. You won't see me again after that.
No, all right, sir. Deputy, you can take him back down.
All right. Thank you, Your Honor. I don't believe I have anything else on the docket. I will be over in my office if you need me, if you just want to give our office a buzz.
Cool. Are there any traffic cases pending here? We get those before the civil case.
Actually, I will stand by in the event that I'm needed for that.
I saw some people pointing back there. Just approach the district attorney here if you have a traffic case you'd like to fight.
Got a case you're looking to fight?
Yeah. Record number 49791.
49791?
Yes.
Okay, give me just 1 second, sir. And you, sir, Mr. Penwall?
Yes.
Your Honor, Mr. Penwall has a citation he wishes to fight. It was issued by Lieutenant Mike Simon, record number 49791. It appears to be a resist, delay, or obstruct peace officer, which is normally a misdemeanor that Lieutenant Simon filed as an infraction instead. Which obviously is his right to do so, to downgrade the charge.
Okay. I don't believe he is available for court duty today. Let me try to send him a message here, see if we can find him. In the event we can't, we will just reset that so he doesn't have to pay, and it'll move to the next court date. But just give me a minute here.
Your Honor, I please get this on, this case taken care of. I do have a constitutional right for fair and speedy trial.
Your Honor, the state would step in on behalf of the Los Angeles County Sheriff's Office. A speedy trial. Invoking speedy trial is for individuals that are in custody. They have a right to trial within 60 days. It does not.
Additionally, I would just add that this is not a criminal charge. It's a civil infraction. So, at this point, I have not heard back. So I'm going to say that just in the interest of expediency, we'll just go ahead and dismiss the charge.
Your Honor, I got a quick question. So this officer wanted me to register this this tractor that I was in, operating at the time. I did register it. I have it registered and insured, and I plan to have a towing service, DV Towing, to transfer this tractor from impound to its selling point. Am I still allowed to do that?
As long as it doesn't go on the public roadway other than with the tow truck. Yeah, I don't see an issue.
Yes, like I said, I have plans to have this tractor that is currently still in impound to be, transferred by DV Towing to its selling point.
All right. Yeah, no, that should be fine if you make your private arrangements there. From impound, when you go and check there, just make sure you got your tow truck set up. They're not going to let you drive it out of there, so it's going to have they're going to have to see it go onto a tow truck.
No problem. I thank you, Your Honor, for taking care of this for me.
Yes, sir. So nothing to pay for you, no points, nothing like that. That case is dismissed.
Thank you. Thank you.
All right. Anybody else have a traffic case for the court? I will take that as a no. Oh, yes. Okay, let's hear it.
It's on behalf of Mr. Steve Vickers. He's currently working with DV Towing. He's on shift right now. He had failure to appear for a citation a couple of weeks ago. When he logged into the DMV website there, it was issued at that point that he had a warrant out for his arrest. He then called the DMV. The DMV then stated that he had a court appearance that he did not go into. He had then self-surrendered to the Paleto Sheriff's Office, had explained the situation that he was up in Canada at the time to go see some family, and that's why he was not able to make it to the court date when he got that ticket. I do have on record that he has paid off his ticket after the warrant was issued and cleared, and he had also talked to a Lieutenant Mike as well. If I'm not mistaken, he also did say that Mr. Mike was going to talk to you about the removing the warrant off of his arrest record, the warrant off his record along with the arrest record as well.
Yeah, this is you're talking about the gentleman who turned himself in at the sheriff's office.
That is correct, Your Honor.
Yeah, no, I'll hear from the state in a second, but I can tell you in general my perspective on that is, I don't know maybe why he didn't communicate to the court staff ahead of time that he's going to be in Canada, but here, there, whatever. I appreciate that he came and turned himself in. He paid the fine. I'm not going to impose any additional penalty, so we'll hear what the state has to say.
Thank you, Judge. State objects. Defense counsel. I assume your standing is defense counsel. Is that correct, Mr. Zimmerman?
That is correct.
Thank you. Defense has not presented a legal foundation to sealing an arrest record or striking a warrant. So state objects to that. It appears the case is closed at this point in time. So the state requests that the adjudication remain as it is.
Understood. So, Mr. Remind me your name. Sorry.
Zimmerman, Your Honor.
Zimmerman. I apologize. So, Mr. Zimmerman, he is correct on a technical basis. You do need to demonstrate a point in fact that's supported by the law for me to seal the record. However, it is, in this case, there is an arrest for the failure to appear, but it's just a traffic one. There's no major consequence to it as of this moment. I understand your client's desire to get that off of the record. That's the kind of thing that you can discuss with him, make an offer they can talk about, or you can find one of the reasons permitted by state law to seal or expunge that record. At this, I need to agree with the people on a technical basis that you haven't presented me any of the options that are given to me by the law to do what you're asking.
The only reason why we're asking this, Your Honor, is for the simple fact that Mr. Vickers is actually a tow truck driver within DV. And they have also stated that they weren't aware that he had an arrest warrant for a failure to appear. At that point in time, they did tell him to get it solved as quickly as possible. And they would prefer that the arrest records not go against a potential driver and then make a bad name for DV towing per se.
So here's what I'll do for you. I will temporarily place all of the documents related to this case under seal for 30 days. You have 30 days to get in touch with the district attorney's office, with the representatives from DV Towing, whoever you need to talk to. Come up with a plan. Bring it to me, whether that's expungement through one of the bases provided by law, or whether the state's willing to withdraw and have those charges dismissed voluntarily, something along those lines. After the 30 days expire, those records will be visible to people with access to those systems once again. But I do hear your point. I do sympathize with your client. I wish that he had contacted us ahead of the warrant being issued. I mean, every single citation that every citizen in this county signs, it says the court date right there. It is, generally speaking, not an excuse that you weren't here for the court date, whether that be, someone who works as a senator or a sanitation worker, or anything in between. I do appreciate that what he did with surrendering himself to the sheriff's office. That does go some way in my book. So I'm not going to impose any new sanction as a result of the warrant. He's not going to get any. There's going to be, essentially, for the fail to appear charge, I'm not going to impose any sentence at this point.
He also had stated as well that he had tried to pay online the moment he got the ticket. And he tried using the website of pay fines, pay tickets, pay fine, and none of the above was actually working at that time. I don't know if there was a technical error on behalf of the website themselves, or if it was a typo, but I believe that's what Mr. Vickers was saying to the lieutenant at that time, or the arresting officer, stating that he had tried to pay, but the technical issues were refusing him to pay.
So that's something that I can work with. What I would do is I would direct my court staff here to take a look, make sure that your client did make some attempt to get onto that website and it didn't work. He should have, sent a letter, made a phone call, done something. But if he tried and it didn't work, that makes me a little bit more lenient towards maybe saying that this case needed to be reset instead of a warrant issue. So,
Your Honor,
yeah,
let
go
the
ahead.
record reflect as well that he had tried multiple times within a few hours since he got the ticket. He was aware of the speeding ticket that he was issued, and he had accepted it and had accepted responsibility. He wasn't well aware of the the court date, as he wasn't aware that it was a week from the day that he got the ticket. But he is aware that he takes full responsibility for missing the ticket, missing the court date. But he is he did try to pay the fine multiple times within a few hours after he had gotten that fine, because he knew he wasn't going to be around in Los Santos.
The application is managed by the Information Technology Services of the state courts, so I will get in touch with them. I will see what they have to say, see if they have any records that helps your client, and obviously you're entitled to those if they exist. If that's true, we can talk about it. But what I would like for you to do is take this 30 days. I'm going to seal all of these records related to everything except the original citation, so the arrest and the warrant. I'll seal those for 30 days so that no one other than authorized people by this court on those records. And I will give you 30 days to come up with a solution. And then if the information technology team brings me other information, I'll be sure to pass it along to you and to Mr. Pearson if that makes any kind of a difference on what my ultimate decision is going to be.
Yeah, no, I have no objections, Your Honor.
Do you have a case, sir? I noticed you were standing behind me for a moment.
Yeah.
Do you know what the case number is?
My son had received a citation a few days before his untimely death.
Okay.
We have been receiving mail stating, so I'm just wanting to get it taken off his record due to his passing.
What's this? Do you know what the citation number is? Did you get that on any of the paperwork, or if you can at least let me know his name, I can look it up.
Let me check.
Very sorry to hear about your son as well, sir. I'm very sorry.
So you can approach the podium. I heard part of what you're saying.
It's a Kyle Morrison.
All
right. Hey, Your Honor.
Is it Mr. Morrison? That's you as well?
Yes, my name is Michael Morrison. My son is Kyle Morrison.
Okay. I heard what you said. I'm very sorry to hear about it. Do you know the date that your son received that citation in question?
I believe it was on
I'm pulling the record right now, Your Honor.
09/16, Your Honor. I'm unsure on what the reason behind it was, but my son unfortunately passed away due to a motorcycle accident.
And when did he pass on?
It was 3 days after the citation, so it was on the 19th of the same month.
Your Honor, the state will move to dismiss the citation and to recall the warrant and dismiss any and all outstanding matters for that individual.
Court appreciates the state's willingness here. However, anyways, even if the state had objected, in this case, I would find that that case was moot. There was no chance for the defendant to argue his innocence or guilt. Defendant is now deceased. There is nothing further to be gained by, especially pending a conviction that will not occur. So that will all be stricken from the record. Warrant will be recalled, records expunged, based on the interests of good public justice administration.
Thank you, Your Honor.
Thank you, Judge.
Anything else for the court?
All right. I think that's it, Your Honor. I'll be in my office. Like I said, if you need me, please have one of your staff members buzz me. And otherwise, I'll see you next time.
All right. Thank you, sir.
No, really.
Yeah, I know. We really should. There's a civil case pending, I believe.
Yes, Your Honor. It is.
Hey, William, how are you?
Down here. Oh, I hear you. Sorry, I didn't notice who you were.
Oh, not a problem.
My apologies, Your Honor. It is my client's Nicholas Barmengartner versus a defendant, Chase Gordito.
Giordano. Okay, I see it.
No.
All right. Let's have the appearances. Are both the defendant and plaintiff present?
Yes, Your Honor. It is my understanding that the defendant is representing himself in the civil case.
Gentlemen, you may approach. Mr. Giordano, take the defense table. So you can have a seat there. And Mr. Baumgartner, you're with your lawyers. All right. So this is a civil trial, not a criminal trial. That means there is a different standard of proving what we need for legal culpability here. Essentially, it's not guilt beyond a reasonable doubt, like you may have seen in the criminal trials that just occurred. Well, not criminal trials, but the steps in criminal proceedings that you just witnessed. What I need here is to establish basically what we call a preponderance of the evidence. More likely than not, that one side is telling the truth, that one side is entitled to damages, etc. I'll have the appearances on the record. First, Mr. Giordano, since you're representing yourself, just to confirm, you did have an opportunity to hire an attorney and you chose not to, correct?
No, I did not. I'd make the choice not to, yes.
And you are Chase Giordano, that's correct?
Correct.
All right, and for the plaintiff?
For the plaintiff, it's going to be William T. Stewart, bar number 241053.
And Your Honor, my name is Raylan Zane. I'm just here assisting Mr. Stewart. My bar number is 231065.
Mr. Zane, you counsel of record here, or you're just assisting your colleague?
Just assisting, Your Honor. The attorney of record is Mr. Stewart.
All right. Well, we'll start with the plaintiff. What you got?
Yes, Your Honor. My client is seeking payout due to a matter that had happened on date 10/22/24. My client was removed from the premises of the motel under a call that the defendant had made to 911 services stating that my client was possibly selling an illegal item. I believe the word he used was pills. During that interaction, he was removed and removed from the property per request of the manager, which is the defendant in this. After he made his way outside, he found that his tail lights on both sides were busted out, along with all lights, my apologies, Your Honor, were busted out. Pictures have also been sent to the court as well. He sought to get them fixed at the Plato mechanic. Total was $698. Along with that, shortly after the interaction there, due to my client having to drive to get his vehicle fixed, he was involved in a motor vehicle accident that left him with a totaled vehicle and injuries sustained from it. My client is seeking a total of $398 for the motel rent that was not refunded after the false report from the defendant. Along with that, my client is seeking $681 for the initial vehicle repair and $4,850 for the repairs after the incident, with a total of $5,946.
And you're proposing this is all punitive damages, or some as punitive, some as emotional damage, or
all punitive damage, Your Honor.
So he seeks nothing in terms of emotional damage compensation. It's just the corrective total.
That is correct, Your Honor.
Anything further from the plaintiff?
Nothing further, Your Honor.
Okay. Mr. Giordano,
Yes, Your Honor.
you want to step up to the podium here?
Yes, Your Honor.
Did you have insurance on your car?
You may go ahead, sir.
What was the? Did you have a
All right,
deductible
so-
on it, or?
He did check in. He
I'm
paid for
trying
his
to
fees.
find out why we're
I
looking
rely
for
on my
over
staff for a lot
$4,000
of
if you
issues
could-
that
if
we
you
have
had
out there.
apologize. So you're the manager or the owner of the motel?
Just the
was
manager.
deductible. The total
Okay,
is
but
actually
you have permission from the owner to represent them here?
Holy shit! Well, you need to get
Yes,
a different
the owner
insurance
is out of
company.
the country right
Okay,
now.
thank you.
Okay.
He basically he checked in, and I rely on my staff heavily. So when we get reports of questionable acts, we usually report it right away because we want to try to keep the reputation of the hotel up. In this case, one of my cleaning staff saw something out of questionable, which was the plaintiff over here with pills of some sort, and I acted on that with a call. Because we found it's easier to let the police handle it than try to confront the person because they could be violent.
Can you describe the person to me who made this report to you at all?
It's one of my cleaning staff, Jane Local. She's
Still
one of my
employed with you
cleaners that are
today?
there. Huh? No, she is. She is not.
Fired, quit? What happened there?
So, she was fired because she might have been overacted, and I probably reacted too quickly. But generally, we trust our staff to make good judgment calls when it comes to something like this.
Did she give you any more information as to what she saw or what she thought was going on? She just said pills.
She says pills. She thought she saw someone coming in and out beyond the client who had not been checked in. It was based on that we decided to make the call. It's pretty standard procedure for almost any hotel.
Okay, do you have surveillance cameras?
Unfortunately, we have them in interior in the checkout area, but we don't have any on the parking lot itself.
So do you have an answer for me as to how his vehicle got damaged like that?
That I could not tell you. We are on a fairly major roadway going along the ocean there, and that could have happened at any point when he was there.
Okay. Quick question for the plaintiff's attorney.
Rosa
here,
Elite, that would've been
Mr.
great.
Stewart.
Yes, Your Honor.
Did you make any attempt to subpoena security cameras from neighboring areas? Anything that could prove what happened with this vehicle?
I have not had the chance, Your Honor. There was an error in the software at which we get cases assigned to us, and those actually thrown on me last minute. But we are seeking to subpoena the CCTV along with further reports and documentation of the interaction on the date in question.
Okay. Is there any proof at all of the condition of the defendant's or the plaintiff's vehicle before this interaction?
Just the word from my client. I will have further once I have a chance to be able to look at the full document. Like I said, Your Honor, I was quite underprepared for today's events due to the miserror on the way our cases get assigned. I do apologize.
Understood. Recite for me the damages you want again.
My client is seeking $498 US for the motel rent that was refused to be refunded, along with $698 for the initial vehicle repair and a total of 4,850 for the repairs
Sorry,
after the
698
accident.
for what?
The initial repairs of the headlights and tail lights that were busted out at the motel or hotel. With a
And what the
subtotal.
remaining amount?
I'm sorry.
Go ahead with the remaining amount.
Oh, and then 4,850 for the repairs after the accident. Calls due to having to attempt a vehicle that was damaged, with a subtotal of 5,946.
In that parking lot where the car was, is that the motel's property? Is that public property that adjoins the motel? Is that, what is that?
There is parking on the property, but there's also parking across the street that is not our property, and I'm not sure which side he parked on.
The plaintiff have any input here?
I parked on property right in front of my room.
And just to be clear, so you don't have any kind of a dash camera in your vehicle, nothing like that?
No, sir.
All right, does either side have anything further for me before I make my ruling?
Your Honor, if I may.
Sure.
As for the damage to his vehicle and the accident after, I can't say anything about that. He was there for a short time. I'm not sure how the vehicle got damaged in that time. As I told him before, we'll be refunding his deposit, but there's a 72-hour cancellation fee. So even though he's asking for the room rent back, I cannot give it. That's the hotel's policy.
Understood. Anything else from the plaintiff?
No, Your Honor.
Nothing further, Your Honor.
All right. I am going to award the plaintiff $498.00 in compensatory damages. I do not believe that the burden of proof as to the liability of damage to the vehicle has been met in this court's opinion. Further, no punitive damages are requested, and so none will be awarded. That is the order of the court as to cases 0045.
Thank you, Your Honor.
Thank you, Your Honor.
So, Mr. Baumgartner, you understand that means that, well, since you're named personal, or Mr. Giordano, excuse me, since you're named personally in the lawsuit here, you are required to pay Mr. Baumgartner that amount. Whether your employer can reimburse you for it, that's a matter for you to discuss with them. But you need to pay that within, I believe it's 45 days. If not, he can come back to me and we can start getting into motions to compel and pulling your invoices apart and stuff.
If I may,
Yes,
Your Honor.
Mr. Stewart.
Just to clear the air on something, looks like the suit that was filed was mislabeled. It is not my client versus Mr. Apologies, I forgot his name. Look back at my notes here. It is not Nicholas versus Chase. My client is suing the motel business itself for the damages.
Okay. All right, that makes more sense. I also noticed in the initial paperwork is $398 for the 2 days rent. Is it $398 or is it $498?
It is $398 for the motel rent, Your Honor.
All right, so that's the damages that I'm going to award right now. Find further evidence to prove in either neglection of responsibility, anything like that. We can come back, talk about the damages to the car, but for now, the order will be $398 in compensatory damages. The record for the court case will be updated. What's the name of the motel?
I believe it don't have an official name, Your Honor. I think it's just labeled as Sandy Shores Motel.
Yeah, the owner calls it the Oak Tree Motel, but I don't know if he's ever actually put a sign up for it.
And the postal there is what?
1079.
You said Oak Shores Motel, or what did you say? Oak.
The Oak Tree. It's Oak Tree.
All right. My judgment in that case has been entered. Either party may approach the court after this date if you have further motions, updates, anything like that. But as it stands, the Oak Tree Motel owes Mr. Baumgartner $398.00. That is the judgment of the court.
Thank you, Your Honor.
All right. With that, I believe we are out of session. Thank you all for your time.
All rise.
Thank you, Your Honor. We can file a motion for an amended judgment at a later time, or we can file an additional suit. It's a civil case, so it doesn't fall under criminal statute under the Sixth Amendment of double jeopardy. So we can just sue him repeatedly until we get the right outcome here.
So, like, right now, we're going to go ahead and file for a later judgment. Due to the mix-up of paperwork, I have some catching up to do. Along with it, I've got some subpoenas and everything to send out. Once I get that sent over, Mr. I'm sorry, I don't know how to pronounce your last name, Nicholas. I'll be reaching out to you further for a meeting, for a sit down, where we'll discuss further. Okay. Were you already paid out for your insurance policy on the vehicle damages?
Yeah, I got paid out, but they did make me do a deductible of $4,000 something.
All right. You got any questions for either myself or Mr. Zane here?
Longest court sessions ever, I think.
Yeah.
All right. Thank you, sir. We'll get with you here shortly. And like I said, we'll get you what you're owed. Mr. Stewart is a fantastic attorney, and I have no doubt that he's going to be working very hard in this case.
Thank you.
Absolutely. I will get all that filled out, and I will reach out to you, and we will get you what you are seeking. And we got some work ahead of us, yes, but it will be well worth it.
For sure. Thank you again.
No problem. Thank you, bailiffs.
Alrighty, guys, that is the end of the court session. Mike, massive shout out, dude. You are fantastic up on the bench, I swear. I'm getting ready to send out a message in SLRP to thank everybody for their time. I think that was absolutely amazing. But to the rest of you guys, thank you so much for being here. Sydney dinner's fantastic. I was starving there at the end. It is always super duper fun to get to do court. I'm hoping that more folks will get to see this and get to really enjoy what we do here. I think this is one thing that really sets us apart from different servers is our court. So again, thank you to everybody that came to the stream. Thank you to anybody who came out to court itself. You guys are freaking awesome. And I look forward to seeing all you tomorrow for another edition of SLRP On Patrol Live. We will be starting right at 4 o'clock as I will be off of work. So you guys have a great rest of your night. Thank you so much for being here, and we'll do it all again real soon.
South Girl Scouts.